Just like mentioning.
Yes.
আমার applicant. Oh, with the leave of
Yes.
lordship.
Hey, এসিটা চলছে তো? Yes, sir.
The leave of your lordship, I am mentioning this matter.
Yes.
There is an application in connection.
তো
There is an application in connection with the suit. I have already put my other side on notice, lordship. In a similar matter, lordship had
No, Mr. Mukherjee is there.
Yes.
Do you have anything to mention or
No, my lord. I think, my lord, they gave notice
Lordship,
for mentioning.
Lordship had already released a matter between the same parties in a Section 9 application. The suit is also between the same parties and one more party. If
no, I will release this.
so that
My lord, I can't get to do any matter before the lord.
All right, to be mentioned tomorrow.
I'm good.
So sorry.
My lord, appellate said mentioning a fresh contempt application for inclusion.
Not now, mentioned on Friday.
But I am for the defendant petitioner.
I am for the
No, any mentioning in the original?
Your
set?
Lordship's
Over.
item number.
Fair enough.
Item number 1 for judgment.
For judgment. Oh, acha, you are there. In view of the above, this court is also of the opinion that there is no further requirement to scrutinize the causes shown by the defendant in the supporting affidavit, praying for extension of time to file affidavit statement. In the event any written statement is submitted by the defendant and taken on record, the same shall forthwith be taken off the file and returned to the defendant without any cognizance of it, without taking any cognizance of it. The suit register or suit records wherever it is necessary shall be rectified then. The suit henceforth shall appear as undefended suit. Resultantly, the instant application is dismissed.
Grateful, Your Lordships.
I'm so sorry.
I'm good.
So sorry. If you wish, you can look at it.
Item number 2. India Limited.
I am appearing on behalf of the decree holder, Your Lordship.
Yes.
The decree is against a partnership firm and one of the partners.
Moving ex party?
Yes, Your Lordship. Now, the point is we have tried to serve it on multiple occasions and thereafter being satisfied by Your Lordship's predecessor on 28 February 2025 that they are avoiding service, was pleased to issue warrant of arrest on one address, that is the cause title address. Nothing, the report came back that no one lives there. They have moved. Thereafter, we found out that they have moved to another address. They have moved to another address, and we submitted that before Your Lordship's predecessor. Your Lordship's predecessor was pleased to direct warrant of arrest against at that address also. But however, the police is saying submitting the.
এই শোনো, এই জাজমেন্টটা সার্ভার হয়ে গেলে এর কপি নিয়ে আমার আজ ফাইলে ঢোকাবে।
However, the police authorities at Patna, they have submitted a report that no one is residing of that name. No one is residing there.
Injunction passed.
Yes, Your Lordship. Injunction passed. Now, Your Lordship, although we are a decree holder, we are at Your Lordship's mercy, because although we came to know that they are living at that address, the changed address, the subsequent one, but the police gave the report that no one is residing there. Your Lordship, কোন report টা বলো? On the last
Yes, yes,
occasion,
I got it.
a report was submitted by from the sheriff office. Kindly sees the last line, Your Lordship.
There is no person residing in the name of Navid Vasta at the
Yes,
address
yes.
mentioned here in above.
Our personal inquiries reveal that he is residing there, but the report received from the police station at Patna, they have intimated that no one is residing there. Under such circumstances, is your Lordship pleased to appoint a special officer to make a local inquiry over there, because our personally
What are the properties? Show me from column 10.
except for the no property, except for the PAN card, we don't have any other information, Your Lordship. The PAN,
The property.
We do not have any further information. They are based in Patna, Your Lordship. They are based in Patna. The decree holder is from Kolkata. We only came to know of the PAN because of the business transactions and of the partial.
Even if I appoint a receiver, what will he do?
At least
Receiver cannot be appointed on a natural person. He can be appointed on the properties or bank account, blah, blah, blah.
Only for the purpose, Your Lordship, I am seeking to make an inquiry in order to verify what has come as the report from the police station of Patna, Your Lordship. Nothing much. Only they are verified. Because our information says they are there still residing. Because the first cost title address, they have shifted. We got the intimation that they are living with their family at the new address. If Your Lordship feels, then in that case, kindly gives us a period in the alternative, an adjournment of a fortnight or 3 weeks, Your Lordship. We will make again an
What
inquiry.
I am thinking, I will adjourn the matter. I will direct the police commissioner, Patna, to ascertain and submit a report through its authorized competent officer.
Very well, Your Lordship. That would be.
Asho.
লেখানোর কিছু নেই। আমরা এই ব্যাংকে
কেউ আসেনি আমার টিমের নাকি?
তো পেয়ে গেছি।
না, বা 4 জন আছে আমার টিমে, আজকে এসছে নাকি জানো না তুমি? ঠিক আছে, নো প্রবলেম। কোথাও আটকালে বা কোথাও অসুবিধে হলে সঙ্গে সঙ্গে আমায় থামাবে, থামিয়ে জিজ্ঞেস করবে 15 বার। আমি কিচ্ছু মনে করবো না, কিন্তু ইনকমপ্লিট নিয়ে চলে যাবে না। ঠিক আছে বাবা? লেখো, দিস ইজ অ্যান এক্সিকিউশন অ্যাপ্লিকেশন arising from a decree dated
First February
2024.
February 1, 2024. It's a money decree or what?
Money decree, Your Lordship.
Full stop. It is a money decree for about a sum of rupees
40 lakhs, Your Lordship.
40 lakhs. 40 lakhs decree, how could it be done here?
Your Lordship.
40 lakhs decree from High Court?
10 lakhs and above, Your Lordship.
No.
The Commercial Code Act.
Huh?
There is a notification from 10 lakhs and above, Your Lordship.
ঠিক আছে, কি বললাম? 40 lakhs. The judgment debtors, as per the information received by the plaintiff decree holder,
The judgment debtor number 2
is a resident of Patna. The judgment dated number 2 is a resident of Patna. Full stop. Paragraph. Several attempts made to serve notice upon the judgment debtors, but every time such attempt went into vain. V-E-I-N. Went into vain. V-E-I-N. The report of the sheriff, the report of the office of the deputy sheriff, dated August 11, 2025 shows that there is no person residing in the name of the judgment dated number 2 at the address mentioned therein. However, the decree holder submits, decree holder submits that the judgment dated number 2 is residing there at the address given in the application at Patna.
Your Lordship, not in the application, the subsequent address provided, which is also mentioned in the report, Your Lordship.
আচ্ছা আচ্ছা তাহলে কি বললাম? At the address being bold করে লেখো, ডিড এইটা পুরো লিখে দাও, এই দেখো বাবা, এই অবধি দেখে দেখে ছেপে দাও, এইখান থেকে শুরু করো, এইখান থেকে শুরু করো, এই অবধি দেখে দেখে ছেপে দাও। তুমি এখনই করে দাও।
Address or any other address. Wherever this address or any other address. Just being a cat and mouse game with people.
Full stop. In view of the above, the learned advocate on record for the applicant judgment debtor shall serve a copy of the execution application at the office of the Commissioner of Police, Patna. Full stop. Forthwith. Full stop. Along with a copy of today's order. Full stop. Paragraph. The Commissioner of Police, Patna then shall depute a responsible police officer, and upon causing an inquiry shall file a report, shall send a report at the office of the deputy sheriff of this court through such responsible police officer to be deputed by him. With regard to the whereabouts of the judgment dated number 2, that is Navit Vasta, N-A-V-W-T-V-A-S-T-A.
N-A-V-N-W-T, Your Lordship, if I may.
N-A-V-W-T. N-A-V-W-T.
Post title কি আছে?
N-A-V-N-W-T.
Yes, Your
এতে
Lordship.
লেখা আছে তাহলে ভুল, রিপোর্টে ভুল লেখা আছে।
Yes, Your Lordship.
N-A-V-N-W-T-V-A-S-T-A, নবীন ভাস্তা নাম একটা, হ্যাঁ, বোল্ড। যাই হোক যা আছে নবনীত ভাস্তা, হ্যাঁ, বোল্ড। কি বললাম? To be reputed by him. The report shall be filed on the next date. The report shall be made available before this court before the next date. Paragraph. Depending upon the situation, this court may proceed to issue warrant of arrest of the judgment debtor number 2. And in that event, such warrant may be directed to be executed through the local police station where the judgment debtor number 2 resides. Paragraph. The matter shall appear under the heading New Chamber Application on আজকে কত? হ্যাঁ, December 18,
Great,
2025.
Your Lordship. One humble prayer, Your Lordship.
Take microphone, take my.
One humble prayer, Your Lordship. If Your Lordship kindly directs the Commissioner,
I can't hear you.
if Your Lordship kindly directs the Commissioner to give the whereabouts of the judgment debtor number 2, if even if he is residing anywhere except this also, if he can be traced out.
So I've
Oh, wait.
directed to give the whereabouts.
Wait, Your Lordship. And Your Lordship had directed the subject to correction, the applicant judgment debtor. Possibly it would be applicant decree holder.
Applicant decree holder. লিখেছি কত? জাজমেন্ট ডেটার।
One place will not do that.
করব। থ্যাংক ইউ।
Grateful.
ডিগ্রি হোল্ডার করে দিও বাবা। বুড়ো মানুষ বুড়ো হয়ে গেছে, বলতে ভুল হয়। ডিগ্রি হোল্ডার করে দিও। ঠিক আছে। কি? প্রিন্টিভ ডিগ্রি হোল্ডার ঠিক আছে। কি কিভাবে শুরু করেছো বলো? হ্যাঁ, জাজমেন্ট ডেটার নাম্বার 2 করে দাও। না, তাহলে প্রথমে জাজমেন্ট ডেটার্স থাকুক আর রেসিডেন্ট অফ পাটনা করে দাও। আর সিচুয়েটেড অ্যান্ড রেসিডেন্ট অফ পাটনা, সিচুয়েটেড অ্যাট অ্যান্ড তারপরেরটা ঠিক আছে। চলো চলো চলো, থ্যাংক ইউ বাবা। চলো নেক্সট।
Number 3. Rahi instructed immediate.
On my personal ground, Lego this application, comma, on my personal ground, this application, comma, on my personal ground, comma, stands released from my list. Paragraph. Records are directed to be sent forthwith before the Secretariat to the Honorable the Chief Justice for taking appropriate steps for assignment. Thank you.
All my matters are being released. All my matters now are being released.
Destiny.
Item number 4.
Well, I'm for the respondent. But I am appearing on behalf of the plaintiff petitioner. This is my application for acceptance of my written statement.
Extension.
Additional written statement. Yes,
Oh, you are for the plaintiff.
I am for the plaintiff. The
Rule
defendant
5.
file its yes counterclaim. I have sought to file an additional written statement. I have to indicate that your lordship, it is not compliant with Order 6, Rule 15A. I will be praying for prayers in terms of Masters C, that leave be granted to the plaintiffs to file their additional written statement within such extended period of time. Lordship will grant me 2 days time so that I can put in my statement of truth. It is not there. I had indicated
Statement of?
statement of truth is not there. Order
Statement
6, truth.
truth. Acha, acha.
That is missing. It has to be reaffirmed. It is everything else is there. It's an affirmative
All right,
statement.
all
It has
right,
to be
all right.
reaffirmed. And one more thing, your lordship, since I know your lordship's view, I would want to rely on the order passed by Justice Honorable Krishna Rao when the written statement was accepted with regards to the
Not
cost.
not now. At the time of hearing, first you cure the defect and come back.
Very well.
Then you will recut it.
Very well.
No problem.
2 days time.
Ashun. Mr. Sharbojit Mukherjee, Learned Counsel, appearing for the plaintiff,
Plaintiff.
submits that this is an application for prayer for extension of time to file additional written statement. Since the defendant, how many?
One.
আচ্ছা plaintiffs are multiple, so plaintiffs করে দিন কি বললাম submits application for prayer for with a prayer for extension of time to file additional written statement, since the defendant has introduced a counterclaim in its written statement. Paragraph. He submits that, listen to me. He submits that there are some formal defects in the application and he prays for leave to.
In the written statement. Additional written statement.
There is some formal defect in the additional written statement already prepared
And affirmed.
and he is praying to cure such, he is praying for curing such defects. Praying for leave to cure such defects. Praying for leave to cure such defects. Paragraph. Mr. Full name? Shailendra Tiwari, Learned Counsel, appears for the defendant. Paragraph. Considering the submissions made on behalf of the parties, for the ends of justice, leave is granted to the plaintiffs. Leave is granted to the plaintiffs. Leave is granted to the plaintiffs to cure the formal defects in its additional written statement proposed to be filed within a period of 7 days from date. Paragraph. The matter shall appear under the heading.
Only one indulgence, Milord.
Eh?
The fresh copy may be served upon other. Correct. Obliged.
Poster. A cured copy shall be served upon the learned advocate on record for the defendant.
Obliged.
Paragraph. The matter shall appear under the heading New Chamber Application. আজকে কত বললে জানো 25 New Chamber Application on December 16, 2025.
Obliged.
The lordship will kindly keep in the second week if possible.
Huh?
Second week of December is possible.
Comes. You have any personal difficulty on 16?
On 6.
You have personal difficulty, very well.
Grateful.
December 11, 2025.
তাতে অসুবিধা নেই।
Obliged.
Grateful.
Item number 5. Mamta Jaiswal.
But I appear for the decree holder. On the last occasion, my lord, your lordships was pleased to appoint a special officer to, my lord, make inventory of the immovable properties mentioned in my execution petition. Now, my lord, I have seen a copy of the report. It appears that the immovable properties are no longer owned by my lord, the judgment debtor. Now, my lord, we've written to the banks also. One bank has responded to our notice along with the order and the execution petition. My lord, the bank says that the account number mentioned in my petition is a loan account. That is number one. Number two, they say they have another account which is a current account, but since that number is not mentioned in our petition, therefore they cannot take any action against that current account. So that is where we stand. We have emailed the judgment debtor based on the email which we obtained from the MCA records. We have tried to serve.
Come up with a supplementary affidavit
My lord.
giving that account on the next day.
Very well, my lord. And my lord, one more, my lord, prayer. My lord, the directors of the judgment debtor is a limited company. My lord, I was, my lord, wondering if we could, my lord, indicate the details of the directors of the judgment debtor
What
also.
you will get from the ROC.
Yes, my lord. So, my lord, we
So
can
get it
indicate.
done.
My lord, we can indicate that in the supplementary affidavit.
That's up to you.
Very well.
Your
That's
Lordship,
up to you.
I am the receiver appointed in this matter.
Let me see.
I am filing my report before your Lordship.
Let me see.
11 November.
Yes, Shreya Ghoshdostida.
Yes, your Lordship.
You have received your remuneration.
Yes, I have received my remuneration.
Madam, there was no direction for circulation of report.
I am carrying the
Minutes.
report.
I have the
Oh.
minutes. I
Huh?
have the minutes. I have the
Circulated
minutes.
report.
I have the minutes, my lord.
Oh, you have the
The
minutes.
Yes.
All right. Yes. Pursuant to the order dated November 11, 2025. Pursuant to the order dated November 11, 2025. Learned receiver appointed by this court files a report. You should come with in a sealed cover,
I am carrying.
and you should not have opened it. It has to be sealed when handed over to court. Court will open it. Right? Next time, don't do this. Right? And never serve unless minute, yes.
No, I have only circulated the minutes of
All right.
inspection.
So when you must file the report in a sealed cover, দরকার নেই আমি কিওর করে দিচ্ছি full stop. কি বললাম? Files a report today. Files FILES today. Comma, the same is taken on record. Full stop. Learned receiver shall serve a copy, has served a copy of the report. The learned receiver, comma, pursuant to the leave granted by this court, comma, has served serves a copy of the report to the learned advocate on record for the plaintiff decree holder in court today. Full stop. Paragraph. Pursuant to the prayer made on behalf of the plaintiff decree holder, leave is granted to the plaintiff decree holder to file a supplementary affidavit disclosing certain material particulars which the decree holder has discovered at a subsequent stage. after the inventory has been carried out. Full stop. Such supplementary affidavit shall be filed within 7 days from date. Within a week from date. Within a week from date. Paragraph. The matter shall appear under the heading. Acha. Next. Considering the direction made by this court on November 11, 2025, it appears to this court that for the time being, the learned receiver is not required to do anything until further order. Until further direction upon her. Paragraph. The discharge of receiver. Paragraph now. Sentence, sentence paragraph. The discharge of receiver shall be considered at the appropriate stage. Sure.
Paragraph 4, 5, 6 of your lordship's last order, your lordships has directed us to serve a copy of the execution petition as well as the last order upon the learned district judge, Alipur Court. But we have done that. The affidavit of service has been made part of your lordship's records.
Affidavit of service today you are filing.
Yes, but we have handed up an affidavit of service today. Yes.
Mathar upor affidavit first sentence affidavit of service filed in court today is taken on record. Last sentence korun order. Notice has also been served upon the at the office of the learned district judge,
Alipur Court.
Alipur.
And my lord, the learned sheriff was also directed, my lord. Paragraph 5. Both the plaintiff and the office of the sheriff are directed to serve a copy of the last order dated September 15 along with a copy of the entire set of executive application.
The matter shall appear under the heading New Chamber Application on December 18, 2025.
Lord, your lordships have directed the learned sheriff to file a report as well. But I am not aware if the report has been filed before your lordships. Report file.
The report filed by the office of the deputy sheriff. The report filed by the office of the deputy sheriff today in court is taken on record.
Grateful, madam.
Thank you.
All persons being arrested, my lord, are keeping my lord enlisted and to be, my lord, subject to look crime considered. Because of the person need to be produced to you.
কবেকার ডিরেকশন ছিল জাস্টিস রাও সাপ্লিমেন্টারি লিস্ট করে দাও 2 PM
Grateful, madam.
এগুলো সকালে মেনশন করবেন না না ওয়ারেন্ট অফ অ্যারেস্ট রিটার্নেবল আছে আজকে প্রডিউস করা এটা আবার আসতে পারার কি আছে সেটা তো লিস্টে তো আমায় আনতে হবে তারপর তো নন কমপ্লায়েন্স দরকার হলে রেকর্ড করতে হবে সকালবেলা এসে আমার কোর্ট অফিসারকে বলি আপনি থেকে বলিয়ে দেবেন
This one is also my bad.
I appear for the decree holder. Lord, if Lordship would kindly see one of the last order. September 22, 2025. Lord, there were 3 directors of the judgment letter. Warrant of arrest could not be executed against one of the directors as she was a woman. And warrant of arrest was already issued in respect of the other 2 directors. Now, my lord, today is the returnable date. So far as the warrant of arrest in respect of the other directors are concerned. And for the lady director, my lord, pursuant to the direction given on September 22, 2025, a subpoena was issued through the, my lord, concerned police station. There is Okla Industrial Area Police Station, Delhi.
So today, for what purpose?
Whether last order
রিপোর্ট ফাইল করে যেটা আগেরটাতে 2 নম্বরে করেছি তুমি কমিশনার পুলিশ কমিশনার পুলিশ দিল্লি রিপোর্ট ফাইল করতে আগে দেখে দাও আছে নেই কি বলছে ব্যাকড্রপটা বলবে ওরা ওখানেই থাকে এই ইনসিডেন্ট ঘটেছিল আমরা রিপোর্ট করেছি ও ওখানেই থাকে ওইটা তারপর আবার কি হলো ফার্স্ট সার্ভিসটা নিয়েছিল ফার্স্ট সার্ভিস অফ এক্সিকিউশন তারপর সেকেন্ড টাইম যখন আবার ফার্স্ট সার্ভিসটা করলাম শিডিউল অ্যাপিয়ার দেন যশোর পার্সোনাল অর্ডার সার্ভিস তো তুমি ডাইরেক্ট কোম্পানির রেজিস্টার্ড অফিসে করেছো এই ডিসিপ্লিন অ্যাড্রেস
The warrant of arrest has not yet been issued.
No, it was issued. There is
The report,
kindly see the order dated 8th of September 2025.
দেখছি।
Pursuant to that, this order was issued. So it was issued in 4 names. বাড়ির অ্যাড্রেস মানবিকা এটা কি বাড়ির অ্যাড্রেস এটা বাড়ির এটা না এটা ওই অফিস হয়ে গেছে তোমার অ্যাফিডেভিট অফ সার্ভিসটা বার করো সার্ভিস হয়েছিল ফার্স্ট টাইম টিম ডেলিভারি দিচ্ছে এখানে পেয়েছে
But the report shows warrant of arrest.
আমি ব্যাকগ্রাউন্ডটা বলি আমি ভুলে গেছি পুরো লেফট এই অ্যাড্রেসটাই তো ওগুলাটাতেই না এইটাতে বলেছি হ্যাঁ ঠিক 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 ঠিক
Fourth November report shows the report of the report for the warrant of arrest is duly prepared and will be submitted to the court directly. So warrant of arrest has not yet been issued by the office of the sheriff. Then 6th September. 6th September তো আগে 4th November এসে গেছে। Oh no, it is 6th November.
দেখতে দাও মাথা লাগাচ্ছে in fact, I'll just indicate to your lordship why the warrant of arrest was issued. We served the execution application on the judgment debtor. We found out 3 addresses. One at Okla Industrial.
That I've seen. One has been first served, then again said nobody decides.
Yes. So the person was there. but the second service was purposefully avoided. Hence, the warrant of arrest was issued by the order of 8th of September. But Murad, so far as Malabika Sengupta is concerned, warrant of arrest could not be executed against her as she is a woman.
Because lady,
Now, Murad, but there are other two directors whose names Lordship will find in the order of Murad, September 2022. Murad, Adesh Kumar Gupta and Rasul Ahmed and Mohammad Fayaz. Murad, warrant was already pending against them. But Murad, we are unaware regarding the status of the warrant that was already issued against the gentlemen who were directors of the company. warrant আছে।
warrant was issued against the two male directors. Show me which order.
Murad, 8th of September 2025.
But you don't know what is the fate of it.
Yes.
These are the copies of the warrants. 4 warrant of arrest.
Decree holder was directed to take appropriate steps to file requisite in the department for issuance of warrant.
Yes.
The warrant has been issued.
Yes.
Warrant was executed through the there local.
ওই ওখলা ইন্ডাস্ট্রিয়াল সেটা তুমি জানবে কি করে? আমার চিঠিতে লেখা। লিখতে হয়।
Delhi Police Headquarters.
Yes, this is the Delhi Police Headquarters, Jai Singh Road, New Delhi. This is the
Requisite.
requisite.
কোথায় পেলে?
Commissioner of the local police. Department চেয়েছিল নামগুলো যে
So the local police officer in charge shall inform.
Yes, they had to inform.
Ashu.
But we are also unaware regarding the fate of the subpoena that was issued on the on Mrs. Sengupta, who is also a director of the judgment debtor.
The order dated, this is an execution application. Full stop. The decree is dated
5th October 2023.
October 5,
23.
2023. October 5, 2023. Full stop. It is a money decree
Yes.
for a sum of rupees
1,86,92,646.
লিখেছেন 1,86,92,646
646.
এগুলো লিখে নেবেন সঙ্গে সঙ্গে paragraph. The order dated September 8, 2025 shows that direction was there for issuance of warrant of arrest against the judgment debtor number.
But judgment debtor is the company, and the warrant of arrest was issued against the.
Oh, judgment debtor is the only company.
Yes.
The warrant of arrest was issued against the MEL director, MALE, MEL director of the judgment debtor company. Paragraph. It is submitted that after the warrant has been issued by the department, by the office of the sheriff of this court, comma, the decree holder is not aware of, decree holders, plural, decree holders are not aware of the subsequent development thereupon. Accordingly, paragraph. The decree holder plaintiff shall serve a copy of this order at the jurisdictional police station at Okla Industrial Area, comma, phase PHAC dash Roman 1. এই Okla Industrial Area থেকে phase dash Roman 1 of the bold. Full stop. Right?
Yes.
Full stop. Paragraph. The office of the কি বললাম আগেরটা? Copies of today's order. Copy of today's order. Upon the jurisdictional and shall file an affidavit of service on the next day. Paragraph. Similarly, the office of the deputy sheriff shall also serve a copy of today's order at the jurisdictional police station. ওই যা বলেছি. Full stop. Full stop. The jurisdictional police station then shall take necessary steps with regard to the warrant of arrest already issued and shall submit the current status report with regard thereto before the office of the deputy sheriff of this honorable court, of this court, positively within 2 weeks from the date of receiving the communication from the office of the deputy sheriff of this court. Paragraph. The office of the deputy sheriff of this court then shall file a composite report after receiving the report from the police authority. The office of the deputy sheriff shall also serve a copy of today's order upon the concerned jurisdictional police commissioner at for Okla Industrial Area Phase 1. এটা bold দিদি. Paragraph. The matter shall appear under the heading New Chamber Application on January 8,
Right.
2026. 2026. এইগুলো না ওনাকে ফেরত দিয়ে দাও এগুলো ওনার
Only
কাগজ
one indulgence, my lord. If a status report,
ঠিকটাই বলুন আমি বলে দিই আমি দেখিয়ে দিই নাহলে বুঝতে পারবেন না এই যে লাস্ট লাইনে আছে দেখে এখনই ফেরত দিন কারণ এটা ওদের কাগজ You take back this paper after she writes down.
only one indulgence, my lord. If a status report can also be called for regarding the subpoena that was
সাবপিনা রিপোর্টটা কে দেবে রেজিস্টার আপনার the report of the deputy sheriff comma the report of the deputy sheriff to be filed comma as directed above shall also contain the latest status with regard to the subpoena জানেন তো বানান which has already been directed to be issued.
Great.
Excellent. Paragraph. The learned advocate on record. Thank you. এগুলো আপনাকে এত procedure. The learned advocate on record for the plaintiff decree holder shall take all necessary steps, including putting the necessary requisition at the office of the deputy sheriff of this court so that the matter can be expedited.
Great.
Item number 7.
Lord, I appear for the petitioner. This is an application in an undefended suit. For my lord, application in an undefended suit for leave to disclose additional documents and for leave to my lord lead evidence through my lord another witness to prove those additional documents. This is
Where
my,
is the defendant?
because it's an undefended suit.
Oh, undefended.
There is no defendant, my lord. So I have only
So additional written statement. Why?
additional documents.
Additional document.
Additional written statement.
That's right. Defendant is not there.
So additional documents, my lord, we have explained why, my lord, the additional documents are necessary only to substantiate a part of my third claim.
Show me the provisions.
Yes. Will your lordship
Because
kindly
after
permit
this
Mr.
Commercial Court Act, show me the provisions.
Kindly comes to order 11. My lord,
Mr.
as
Thakkar.
amended,
I've delivered the judgment today. It is server. Huh?
I'm not aware of the outcome, my lord.
I have dismissed the application. Written statement, if deposited, is directed to be taken off. এই ওইটা বলেছো সার্ভার করে দিতে সার্ভার হয়ে গেছে চলে গেছে
আজকে আইটেম অন ছিল
হয়ে গেছে দেখে নিতে বলো তাহলে আমার একটা প্রিন্ট আউট দিয়ে দাও
my lord, kindly comes to order 11, my lord.
এটার মধ্যে ঢুকিয়ে দাও Order 11.
Yes, my lord, as amended by the my lord Commercial Courts Act. Order 11, Rule 1.
Wait. Because after amendment of this Commercial Court Act, after all, after my elevation, this act has gone a sea change.
Matter of 2 days, my lord. Lordship will be shown these provisions every day.
Order 11.
Rule 1.
Yes.
My lord, let me start with sub-rule 1 of Rule 1.
No, let us start it from the beginning.
Yes. Plaintiff shall file a list of all documents and photocopies of all documents in its power, possession, control, or custody pertaining to the suit along with the plaint.
In one matter, I have delivered a judgment. That's on the defendant's case. Mr. Hashnuhana, yes, Hashnuhana Chakraborty, she appeared. I allowed that. That's also, yes, that's also. So,
And the provisions itself is clear. If Lordship finds reason
all right,
in the
let me
application,
read. In any suit, the plaintiff or defendant, by leave of court, plaintiff or
Lordship is
defendant.
looking at, my lord, the
One, discovery.
disclosure and discovery of documents, not the unamended one. The
No, Order 11, Rule 1.
sub rule 1.
First, I am on Rule 1.
Rule 1 has a sub rule. Lordship is looking at the amended provisions or the unamended.
1 second. Yes. Amendment 1. Amended.
Yes, disclosure and discovery of documents. Plaintiff shall file a list of all documents and photocopies of all documents in its power, position, control, or custody pertaining to the suit along with the plaint, including documents referred to and relied on by the plaintiff in the plaint, documents relating to any matter in question in the proceedings, in the power, position, control, or custody of the plaintiff as on the date of filing of the plaint, irrespective of whether the same is in support of or adverse to the plaintiff's case. Nothing in this rule shall apply to documents produced by plaintiffs and relevant only for the cross-examination of defendant's witness or in answer to any case set up by the defendant subsequent to the filing of the plaint or handed over to a witness merely to refresh his memory. So these are the exceptions. Then 2. The list of documents filed with the plaint shall specify whether the documents in the power, position, control, or custody of the plaintiff are originals, office copies, or photocopies.
Oh,
And
wait. Yes.
And the list shall also set out in brief details of parties to each document, mode of execution, issuance or receipt, and line of custody of each document. Then sub-rule 3, the plaint shall contain a declaration on oath from the plaintiff that all documents in power, position, control, or custody of the plaintiff pertaining to the facts and circumstances of the proceedings initiated by him have been disclosed and copies thereof annexed with the plaint, and that the plaintiff does not have any other document in its power, position, control, or custody. Explanation: a declaration on oath under this sub-rule shall be contained in the statement of truth as set out in the appendix. So these 3 sub-rules of, my lord, Rule 1 postulates that the plaintiff has to disclose all documents which are there in his power, position, control, or custody when he is instituting the suit along with the plaint, with a declaration that he has disclosed whatever was there in his possession, he has disclosed the same. Then comes, my lord, 4. There is a situation envisaged under the code. In cases of urgent filings, what would be the situation? In case of urgent filings, plaintiff may seek leave to rely on additional documents as part of the above declaration on oath, and subject to grant of such leave by court, plaintiff shall file such additional documents in court within 30 days of filing the suit, along with a declaration on oath that the plaintiff has produced all documents in its power, position, control, or custody pertaining to the facts and circumstances of the proceedings initiated by the plaintiff, and that the plaintiff does not have any other document in its power, position, control, or custody. So there is a window of 30 days in case of an urgent filing from the date of institution of the suit,
Subject to the leave of
the court. So this is one exception. Then, my lord, sub-rule 5. The plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, position, control, or custody and not disclosed along with the plaint or within the extended period set out above, that is this 30-day period, save and except by leave of court, and such leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure along with the plaint. Therefore, sub-rule 5 envisages a situation where even beyond that 30-day period, there can be disclosure at the instance of the plaintiff.
Which are 9 and 10 for defendants.
9 and 10 for defendants. Yes.
I have delivered my judgment on
because
9
the
and
same
10.
principle, same analogy applies. So what the plaintiff is required to do is take out an application.
একটা judgment দেখতে হবে না আমাকে ফাইলটা দাও আমি দেখিয়ে দিচ্ছি আমার আজ ফাইলটা দাও না ও ওটা লাগাচ্ছে না সেটা ঠিক আছে আমি পরেরটা দেখাবো ওটা একই গ্রাউন্ড এটা দেখো তো, এটা একটা ওদের দেখিয়ে দাও, ওটা দেখে নি, বের করে নি।
Sudhir Kumar is the parent judgment on this, my lord. Everybody, we are citing Sudhir Kumar. Lordship has taken note of that. No, it is the dependent.
And I have held that there is no
Lordship has considered
limitation of
Sub
time
Rule 9.
period
Yes.
beyond which stage of the trial of the suit it can be. I have held in one paragraph.
Para 20. Not an absolute bar in disclosing documents at a subsequent stage of the proceeding. Court is to examine the reasons shown by the applicant, and if reasons are just and cogent, application will be allowed. Because at the end of the day, an adjudication on merits is warranted, and if documents are necessary as per the plaintiff to prove its case or the defendant to dislodge the claim of the plaintiff, this can be allowed. November 19, 2025. Mascot Petrochem Private Limited versus SCI DPL. Just that, my lord, it is for the defendants in this matter.
That's why I said. Dekhi. Now let's see the application.
Will your lordship permit Mr. Chaudhary to place the application?
Yes.
My lord, this application is
Come on.
My lord, this application is in a plaint in which we seek a money decree. I'll briefly summarize the facts of the plaint before I come.
Not required.
Very well, my lord. Then
It's
kindly
a
comes to
money
the
decree, claiming for a money decree.
very well.
Right? Now you show me the explanations.
Yes, my lord. Kindly comes to the application, my lord. The first paragraph of the application sets out the prayer in the plaint, which is the money decree. Now, my lord, the plaint
Show
was
the explanations. Why you are seeking to disclose today?
yes, my lord.
And what prevented you not to disclose at the relevant point of time? That's all.
My lord, if my lord kindly comes to paragraph 4 first. The claimed amount has been bifurcated into two. As will appear from the plaint filed in the instant suit, the claim of the petitioner is twofold. Has my lord found paragraph 4?
Yes.
There's a claim of USD 24,000 towards payment of detention charges incurred in having to detain the vessel. So this was a vessel to which the defendant was supposed to transport our goods, but that was not done on time. Hence, we had to detain the vessel for a longer time so that the defendant could transport our goods. And that is what we are claiming. One part of the claim is for that. And the second part of the claim, my lord, is a claim for the expenses incurred by the petitioner in loading goods of equivalent quantity and quality as that of the failed consignment. So, my lord, what happened in this case was the defendant was not able to deliver some portion of the consignment which they were supposed to. Hence, we had to procure the consignment from a source in Singapore when the vessel was supposed to go from Kolkata to Hong Kong. So, it had to berth at Singapore specifically to ensure that the goods which were not delivered by the defendant was taken from another unit. In this respect, my lord, we wish to adduce certain additional documents in page 6, in paragraph 6. Paragraph 6, the following documents required to be disclosed in the instant suit and proved by way of oral evidence of a further witness. We have set out the liner booking note dated January 21st, 2021, which is regarding the the hiring of the vessel from Kolkata to Hong Kong. Then there is an email with the shipping agency which would be transferring the goods from the third party because the respondent was not able to meet their obligations under the contract. And there are some emails which show the correspondence as to how the breach in the contract was finally rectified by us.
Explanation.
My lord, before that, if my lord kindly comes to paragraph 5 once.
Show me the reasons why you could not disclose it at the time of filing the plaint.
If my lord comes to paragraph 13.
1.3.
1.3. The transaction in question was the year 2021. At the time of institution of the suit, only those documents which were available with the plaintiff were disclosed with the plaint. Very recently, on a query raised by Sri Gautam Das, who is our Deputy General Manager, with its sister concern, Usha Martin, this is our concern in Singapore. There's an email dated 5th September 2025 has been issued by them. Here in this email, which is at page 71, there's a clarification that there was a shortfall of one reel. This was a reel of steel iron which was supposed to be transported by the defendant to the cargo at Kolkata. That was not done by them. There was a shortfall of one reel which was scheduled for delivery to COSL. My lord, COSL is the entity which
Not
had finally...
required, sir.
Very well, my lord.
You have to show the reasons that this is the reasons, my lord, for which though the documents were there, I could not disclose at the time of filing of the plaintiff.
Very well.
Filing of the plaint.
My
Show
lord,
me that paragraph.
My lord, it kindly comes to paragraph 5, my lord. During the hearing, two specific queries were raised, and in response to those queries, we are actually providing these further documents. Paragraph 5. During the course of arguments, has my lord found that paragraph?
Yes.
During the course of argument. Yes, my lord. So there were two queries which fell from this court. On what basis was the 24,000 USD shown to have been charged by the freight forwarder of the petitioner towards detention charges? And what would have been the comparative cost of loading goods similar to the failed consignment from Kolkata port to Hong Kong port as compared to what happened from the Singapore port to the Hong Kong port? These were two specific queries which were raised. And in response to this only, we are providing these additional documents. Then, my lord, if my lord comes to paragraph 14. So, in response to these factual queries, we have responded and thereby provided these documents. In paragraph 14, it reads, in order to avoid breach in performing its obligations under
Those
the purchase
are merits, sir. On the merit of your case in the plaint.
Yes, my lord.
Those are not material. Show me the reasons.
It's only non-availability of the documents, which is...
Show me the reasons which I can accept as cogent.
Paragraph 13. I have no other reason, my lord. Paragraph 5 has to be read with paragraph 13. When the plaint was instituted and there was no written statement, whatever documents we thought would be sufficient to prove my case, we had discussed.
Can you read 13?
The transaction in question was for the year 2021.
13. এগোচ্ছিল ঠিক, তারপর ঘুরে গেল।
13. Transaction in question was for the year 2021. At the time of institution of the suit, only those documents which were available with the plaintiff were disclosed with the plaintiff.
Correct. Then,
very recently, on a query raised by Sri Gautam Das, the Senior Deputy General Manager Logistics of the plaintiff with its sister concern, an email has been issued by them. This is a new document. From such email, it is evident that there was a shortfall of one reel which was scheduled for delivery to COSL. Well, this email was issued because of a query. This suit had reached the stage of arguments. In course of arguments, only in respect of one part of the claim, it was the query of the court that why did you not try to ship the goods from Kolkata? Why did you do it from Singapore? Then, my lord, we inquired from the plaintiff, and this email of 5th of September 2025 was issued to the sister concern of the plaintiff situated at Singapore. Based on that email, my lord, the further documents, why, my lord, this was loaded from Singapore, these documents had come to our hand, and therefore,
where that is said, where it is said.
from such email, it is evident that there was a shortfall of one reel which was scheduled for delivery. This shortfall is admittedly due to the fault of the. I understand what is
It's on
bothering.
merit. Again, on merit of the claim in the
So in that case, my lord, what I can do is I can just put a supplementary affidavit, and my lord, state in that affidavit, my lord, further, my lord, reasons why, my lord, these documents were not disclosed when, my lord, the suit was instituted. Gives me, my lord, that leave. Reasons exactly in the play.
This is an application filed by the plaintiff, praying for leave to disclose additional documents. Praying for leave to disclose additional documents. Paragraph. The suit has already marked as undefended, DD, undefended suit. Full stop. Paragraph. Mr. Shorbesh Chaudhary, learned advocate, led by Mr. Rajarshi Datta, learned counsel, appearing for the plaintiff, prays for leave to file a supplementary affidavit. Which, according to him, supplementary affidavit, which according to him will contain certain relevant facts, material for adjudication. Paragraph of this application, material for adjudication of this application. Paragraph. For the ends of justice, such leave is granted. Paragraph. Supplementary affidavit shall be filed. Yes. When? On or before?
25th. Second.
December 10, 2025. Paragraph. The matter shall appear. Paragraph. Under the heading.
New motion.
New motion on December 15, 2025.
Number 8. One is limited and another.
This is my application. Yeah, my lord, there was a direction for filing affidavits within 2 weeks after the vacation, my lord. That is not my application, my lord. Lordship are directed to file affidavits, my lord, in this matter. They have not filed yet.
Appearing as new motion? It shouldn't.
Yes, my lord. Affidavit has been directed, my lord. They have not filed with.
That's all right.
Yes.
But the moment affidavit is directed, it should appear as motion adjourned.
Lordship.
হ্যাঁ মানছি ভুল আছে হ্যাঁ ঠিক আছে সে তো তোমরা কি করবে So yes, application for?
My lord, this is an application. If your lordship will see, this is GA2 of your lordship's. GA1 was, my lord, challenging some loan recall notices. That has been stayed in GA1. My lord, my learned friends had pursued that in appeal. The order has been modified, saying that, my lord, they have also filed an application before the NCLT under Section 7 of the Insolvency Bankruptcy Code, saying there is a financial debt, companies should go into CRP. The Honorable Division Bench has said that the NCLT will independently determine the application before it, and also, my lord, the loan recall notice, my lord, whether that is justified or not. Now, my lord, GA2 is filed, saying that, my lord, as per the loan repayment schedule, we have continued to pay money and we have continued to make, my lord, advance payments towards the upcoming
GA2.
installments. Yes, GA2 is what is before your lordship today.
Oh, today GA2 is before
Yes,
me.
yes.
GA2 filed by whom?
By me, my lord, the plaintiff.
Plaintiff.
Only to
yes.
say, here the issue is, my lord, whether the loan has been recalled or not, whether there's a default or not. They say that the entire amount is defaulted and the entire loan has been recalled. I say no, default, if any, was only with regard to one installment, which has been cured by the payment of penal interest. That is the issue. On this, my lord.
So it should be tried along with the plaintiff.
Yes, my
Whether
lord.
the default
Yes,
is there or not.
yes, lordship.
So question of second application does not arise.
Only for this purpose, second application was there, my lord. In the first application, order was passed by the learned single judge that the recall notices be stayed. They have preferred that in appeal, the direction has been modified, saying that the NCLT will decide the application before it. Now, my lord, the subsequent application, GA2, before your lordship, was filed, saying that since the loan recall has been stayed, we have been continuing to make payments as per the repayment schedule, and advance payments have been made. Now, instead of appropriating those payments towards the upcoming installments only as per the loan repayment schedule, they are saying, no, this will be adjusted towards the total outstanding. Only for that purpose, my lord, we had asked for a direction that they be directed to appropriate as per the loan repayment schedule. Or that we deposited before your lordship.
That is also to be decided as an issue in the parent suit.
The difficult.
Whether this amount will be adjusted like this or like that.
My lord,
it should be an issue in the suit.
My lord, I think, my lord, the learned coordinate bench was of the same opinion, so no interim order was granted to me. Affidavits were directed. My learned friends have not filed the affidavit. My apprehension was that, my lord, penal interest will continue to run on this amount if they don't appropriate that money. That is the difficulty.
Since the matter is coming up before your lordship a second time, lordship remember.
What will happen to the direction for affidavit?
Kindly extend it, my lord. I don't think this application is maintainable.
That's different. That's different. Ashun. That will have to be hard. Maintainable or not maintainable will have to be hard on affidavit.
Please.
Since you're taking the point and keeping that open.
Please, man.
Ki bolam? IAGA Com 2. IAGA Com 2 of
2025, man.
2025. Paragraph. This is an application. Kagoj. Filed by the plaintiff. Paragraph. The coordinate bench by its order dated, Mr. Shah?
24th September 2025.
24th September
24, 2025. Has directed the parties to file and exchange their respective affidavits. Paragraph. Mr. Krishnaraj Thakkar, Nataragi Likun, Mr. Ishan Shah, Learned Counsel, appears for the plaintiff. Stroke petitioner.
Multiple plaintiffs, my lord. Plaintiffs.
Two plaintiffs.
Singular.
No, my lord. Plural, that is all.
Plaintiffs. Oblique petitioners. Paragraph. Mr. Krishnaraj Thakkar, learned senior advocate, appearing for the how many?
1 and 2, my lord.
Defendant numbers 1 and 2. The rest are not represented?
Rest are, my lord.
They were appearing in the other applications, my lord.
They are the plaintiff supporting parties.
All right, wait. Ki bola? Pays for an extension of time to file affidavit in opposition. Paragraph, Mr. Huh? Yash Singh. Singhi. Learned advocate, appears for defendant number. Defendant oblique respondent number 3. Who else? Paragraph. The rest of the defendants oblique respondents are not represented. Paragraph. For the ends of justice, time to file affidavit in opposition stands extended till December 19, 2025. Paragraph, affidavit in reply, if any, shall be filed by January 22, 2026. Paragraph, the matter shall appear under the heading adjourn motion in the monthly list of February 2026. Full stop. Paragraph, on the prayer of Mr. Thakkar, the point of comma, the point of maintainability of this application is kept open, which shall be heard first.
Deeply obliged.
Thank you. Because এই অর্ডার গুলোকে অর্ডার ফাইলে রাখছো তো, খুলে দেখাচ্ছ আমাকে, কিন্তু ফাইলে যেন থাকে। হ্যাঁ মানে হ্যাঁ,
This is my application for summary decree under order 13 capital.
was the first day.
The appearing for the first time we need to possibly wait.
Hush. This is an application filed by the plaintiff claiming a summary decree. Paragraph. How many defendants, sir?
There's one defendant.
And how many plaintiff?
One plaintiff.
1:1.
1:2.
Plaintiff. ঠিক আছে উপরে? Paragraph. None appears for the defendant. Paragraph.
Service is not complete.
Huh?
Service is not complete because that's why I said we need to serve.
As the service is not effected as till date, as on date. As on date. Paragraph. Considering the nature of the application, and since the defendant is not represented, and since the service is not effected, comma, affidavits are called for. Paragraph. Affidavit in opposition shall be filed. ওই আগের যে ডিরেকশনটা করলাম ওইটাই লিখে দাও, করে মান্থলি লিস্ট অফ ফেব্রুয়ারি adjourn motion. ওই তো বললাম আগেরটা তুমি দিলে না, 22 রিপ্লাই 22 হ্যাঁ, adjourn motion monthly list of February.
A shorter timeline, my lord. A shorter timeline. In January month list.
Full stop. হয়ে গেল? আচ্ছা, নেক্সট লেখো, the petitioner shall serve a notice along with a copy of today's order upon the defendant and shall file an affidavit of service when the matter shall be taken up next. Thank you.
Grateful. I was hoping for a shorter timeline. Grateful.
Orders. Item number 10.
Please, Your Lordship. Lord, we have not been favored by, my Lord, our advocate on record and the clients actually, with a copy of the previous plaint. So, my Lord, we tried to, my Lord, look into the court records, but
কোর্ট রেকর্ডে এসছে? হ্যাঁ, ঠিক আছে। I'm coming within 5 minutes, then we shall proceed.
in the meantime, may I have a, my Lord, may I peruse the plaint once? Lordship.
দিয়ে দাও ওই প্লেনটা আস্তে আস্তে ছিঁড়ে না যায় বাবা। Yes.
I've now had the occasion of going through the previous plaint, and now, my lord, I can actually indicate why the two cause of actions are absolutely separate. I'll tell you, lordship, why. My lord, I have gone through where perusal would, because, my lord, in this plaint, paragraphs 9 and 10, there is no match. In that plaint, the explanation is given. That is where, my lord, I was getting confused. Now I can, my lord. My lord, before I request your lordship, and my lord, I request for the permission to read along. My lord, may I only indicate this? What I've understood, my lord, is IATA is an organization, and my lord, the plaintiff, being a travel agent, is a member of IATA. Now, my lord, these airlines are also members of IATA. The arrangement is that the member of the travel agents who are members of IATA can enter into agreements with other airlines who are members of IATA. The arrangement is, which I'll now I'll show from the other plaint. The arrangement is, it's all about a discount and commission. If the plaintiff if the plaintiff is successful in selling a certain number of tickets, here in this case it was 7,500 tickets. Till that, was 20% off on the sum of the tickets. On the entire amount of the tickets, 20% discount will be given by the airlines to the travel agent. If it is above 8,000 tickets that they are able to sell, then the discount will increase to 25%. That was the arrangement. With IATA, the arrangement is, which is now clear from this document, this plaint, that there was a commission which they would get over and above the discount given by the airlines. This was the arrangement, my lord. Now, with that agreement, whereby, my lord, there will be a discount given to the travel agent by the airlines, because they are both members of IATA, they will be regulated by the rules of IATA, my lord. Here, what has happened is, there was a clause by which if an additional set of tickets were required by the travel agent in any month, then that had to be given by Indian Airlines. That had to be provided. There's an arrangement to that regard. The allegation was that the travel agent wanted more tickets and wrote to the Indian Airlines.
Travel agent is you.
Travel agent is us, the plaintiff. Wrote to the Indian Airlines, and Indian Airlines sat on that request for more than 5, 6 days, 10 days, which was making it very difficult for the travel agent to continue with this arrangement. Then this was intimated to the Indian Airlines that we can't continue with this agreement. This agreement has to be terminated. And thereafter, now here lies the catch. Thereafter, mutually, the agreement was terminated. And that is why, my lord, in the first plaint, there is no prayer towards, my lord, that cancellation of the agreement. There is no prayer to that effect. And I was confused why. Now comes the answer why. Both the parties, the plaintiff here, did not want to continue with the agreement.
With Indian Airlines.
With Indian Airlines. Indian Airlines agreed. The clause there was there will be no financial responsibility or burden on any of the parties with regard to this cancellation. Cancelled, acted upon by both the parties. Thereafter, Indian Airlines issues a notice. This is this notice, my lord, 99 lakhs was demanded from the plaintiff. That is challenged. And why was that demand? Because there was a clause in the agreement that if there is a difference, if I can't sell a certain number of tickets, then what is the original price of the ticket, that and whatever was the discounted price of the tickets, the difference I have to pay immediately. That is the prayer in the first suit. For that,
so you have in writing communicated Indian Airlines that please terminate the agreement.
Yes, and that my lord will be from the first plaint. I'm very grateful to your lordship that your lordship had called for this plaint. Otherwise, I wouldn't have an answer. But kindly permit me to read along with your lordship. My lord, the first plaint, the pleadings there. My lord, first paragraph is plaintiff is carrying on business as sole proprietor under the name and style of this. Second paragraph, my lord, defendant carries on this. Third paragraph, member of IATA. In fact, the essence starts from paragraph 18. The first few paragraphs, my lord, I'm quickly perusing. 3 is, my lord, kindly permit me to read 3. As a member of IATA, the plaintiff is entitled to carry on business as a travel agent and sell tickets of all airlines which are members of IATA, which inter alia includes the defendant.
এই এটা চালিয়ে দিয়ে যায়নি ফাইনালি টিভিতে বললো যে চালিয়ে দেবে কি বললো সেদিন বললেন না উনি হ্যাঁ আজকে বলো যে সাহেব খোঁজ করছেন জজ সাহেব আজকে আমি উঠে গেলে 1:30টার সময় ওই 1টার সময় বলো যে জজ সাহেব খোঁজ করছেন টিভিটা এখনো চললো না কেন ডিসপ্লেটা আপনি যে বললেন ভদ্রলোক কে এসেছিলেন যেন আমাদের না না রেজিস্ট্রার কাক মাথা ভদ্রলোক হ্যাঁ ওকে বলো যে জজ সাহেব খোঁজ করছিলেন যে আজ
airlines which are members of IATA. My lord, it's an umbrella organization. Now, my lord, paragraph 4. In the year 2002, this is, my lord, what has been reiterated in this plaint as well. Calcutta, Bangalore, Calcutta sector, under this scheme, special discounts were offered to travel agents, which were intended to be passed on to the passengers in order to promote the popularity of this sector. Increased load factor initially was the only travel agent through whom Indian Airlines introduced the scheme to the passengers. This was an agreement in the year 2002-3, 2nd September, copies annexed. Next paragraph. In 2003-4, defendant entered into a similar agreement with Lakshmi Narayan Air Travels, another agent. Paragraph 6. 2004-5, Indian Airlines again entered into 2 separate contracts, one with plaintiff, one with Lakshmi Narayan under the said scheme. Now, this scheme is explained later, my lord. Paragraph 7 is what the terms of the scheme is.
Not required. Then
only, my lord, may I read the next page, 7A? This is what I was referring to, my lord. 7,500, 20% discount, 25% for 8,000, my lord. Special discount, group, if passengers are more than 10 in a group. Now, there's also
you show me that you asked for termination.
Yes,
Which
I'll come to that. Should I go directly to that? Because if I go with the flow of these paragraphs very briefly.
Show me that you have asked for termination.
My lord. My lord, kindly take up. I'll only indicate in pointers 9 and 10 at page, my lord, this is page 4. We say that we have always fulfilled the targets. Paragraph 11, we say the penal clause is vague, uncertain, incapable of enforcement. That is why, my lord, we have asked for a declaration in that suit. So, kindly take up paragraph 12. Shortly after commencement, tsunami hit coastal area. Paragraph 13, this is, my lord, page 5 that I'm reading.
Yes.
Paragraph 13, effect of tsunami was very serious. 14, as a consequence,
yes.
Normalcy was restored. Next page, my lord. Paragraph 15. Plaintiff reasonably expected the travel business to pick up from 2005. Paragraph 16. System followed by travel agent pursuant to issuance of international tickets. This is important, my lord. Kindly permit me to read this. Summarize as follows. Paragraph 16, my lord. A. There is a billing and settlement plan, BSP. I am indicating this because this is, my lord, referred to in the present plaint. BSP, which is a body under IATA. Neutral travel documents, tickets are issued by BSP to travel agents. The travel agents issues ticket to the passengers having the actual travel documents printed through central reservation system. For this purpose, a printer is installed at every IATA member travel agent's location. Next paragraph, my lord. Airlines fixes the quota for each travel agent on fortnightly basis. For example, quota of 200 tickets every fortnight in case of number of
these
tickets.
Are not required.
This is required. I'll tell you, lordship, why. This is the genesis of the termination. That is the reason I'm reading this.
I'm not at all interested because today I'm really hearing an application of them. Whether the suit is maintainable in its commercial division or not. So these are not important. These kindly show me the cause of action in this suit.
Paragraph 24. At page 9, my lord, perhaps it's come this way. It's page 9, paragraph 24.
Yes.
It was not possible for the plaintiff to continue with the said agreement with the defendant, refusing to provide further tickets to the plaintiff even to meet the target. Because, my lord, what I've stated is additional tickets were required. They were not able to give it. To avoid continuous harassment to both sides, it was finally agreed by the parties. Kindly mark this, minute. That the said agreement would be terminated without any liability. Kindly mark this part, minute. Without any liability on either side. This agreement was entered into in the office of so and so, drafted by so and so. Plaintiff thereafter asked to issued a letter recording the termination of the said agreement. Letter was drafted. Letter, a copy whereof is annexed as Annexure G, signed by so and so under compelling circumstances, thereafter served on the defendant on the same date. The date was mistyped. That's stated, my lord. Over the page, paragraph 25. Termination was accepted by the defendant without any demur or protest, and the defendant waives its claim, if any, arising out of the said agreement upon termination of the same. So it was mutually decided and terminated.
Correct.
Nothing, my lord, with regard to the agreement or termination of the agreement is prayed for. Now kindly see paragraph 26. Defendant thereafter issued a letter alleging shortfall in the target per quarter in terms of the said agreement. In reply to the said letter, plaintiff by its letter of 7 September 2005 replied and highlighted the fact that it is impossible to meet the target without a permanent capping. This capping was explained in the middle paragraphs, as to what capping is and how capping happens. 300 plus tickets every fortnight. Plaintiff also pointed out the loss suffered by it because the defendant was not providing the required number of tickets. Next paragraph 27, my lord. Defendant by a letter of 23rd September 2005, copy whereof, demanded payment of 99,16,000. I pause here for a moment. This is the cause of action in this plaint. Can you see the date when this was given? September 2005. Plaintiff by a letter demanded particulars, that's paragraph 28. Over the page, my lord, paragraph 29, requested the defendant to withdraw the unlawful demand of 99 lakhs odd. Then paragraph 30. Defendant has acted in breach of the agreement, which was terminated on 2nd of July 2005. Defendant wrongfully claimed this amount as the difference between the agreed price and normal price. This claim is illegal, null and void, evident from the following. ABCD, I'm not troubling your lordship, the detailed reasons are given. And then, my lord, paragraph 31, page 14. In the circumstances, defendant's claim for this is illegal, null and void, recovery of differential amount between normal price, this, null and void, paragraph 32. The plaintiff suffered substantial loss and damage in the hands of the defendant. And then the next paragraph, defendant has also caused IATA to declare, this is important, paragraph 33. IATA to declare the plaintiff as defaulter and to terminate the plaintiff's sales agency agreement with effect from 22nd January 2006. It would appear from letters of 16th December, 20th December, 22nd December. Plaintiff reserves its rights to take appropriate action against IATA. However, as a consequence of termination of the sales agency agreement of the plaintiff's business has come to a complete standstill. And all international airlines have stopped dealing with the plaintiff on and from 22nd December, even prior thereto. Tickets this. Loss and damage reasonably assessed at 10 crores. Now can you see the prayers in this? First prayer, my lord. It's at page 15, my lord.
Yes.
Now, kindly take up the prayers, my lord, page 15. First prayer, decree for 10 crores. This is, my lord, the reasonable assessment, which is paragraph 34.
So when this plaint was filed,
this notice was not there. This was February 6, 2006. And this plaint was, my lord, filed on 27th January 2006.
So
for the termination, which is intimated, my lord, through the next plaint, that was not served because that letter is dated. It's dated 1st of February 2006. A subsequent cause of action, my lord. And even then, we did not stop there. We approached the commissioner, the travel commissioner, who is an appellate authority, on 12th March 2006. All this is challenged in the second suit.
Yes, then.
My lord, kindly see the second prayer in the first suit. Declaration that cause in the clause in the outbound groups of international sectors agreement requiring plaintiff to make good the difference between the agreed price and the normal price is null and void. So, my lord, that clause of the agreement, termination, there is no, it's mutually agreed, my lord. That clause which gave them perhaps that right.
The Indian Airlines has first filed its written statement.
Huh?
It's
been filed, my lord. Then press C, declaration
in the
that
second suit, IATA has filed its written statement.
IATA has filed. Defendant number 2 could not.
Defendant number 2 could not. Fair enough.
They could not file. I'll tell your lordship why, and that is the reason I would come to that as to why, my lord, this entire plea of, my lord, transferring from commercial to non-commercial.
No. Neither, not
orders.
really important now.
Orders
Let me see the plaint in the second suit.
I'm getting. May I only take 2 minutes? I'll only indicate the other two prayers. The prayer C of the first plaint, my lord, is declaration that the purported target set by the agreement is void. The target of, my lord, the sale of tickets. D, all documents containing the defendant's demand for difference in price be declared as null and void. And then interim interest. These are the prayers. Now, my lord,
kindly come to your cause of action.
In the present plaint.
Yes.
It actually starts, I'll be very, very quick, my lord. Kindly take from paragraph 1, 2, 3. This is the overview. 4 is, my lord, there was an agreement between plaintiff and Indian Airlines. This is...
Show me the 1st of February letter.
Then I have the copy of the plaint, so I'll give the corresponding.
It's annexed to their application.
Yes, madam.
It is annexed.
Yes.
So give it. Show me.
68, madam. Yeah. In the plaint, it's page 52. In their application, it's page 68. Since I'm referring to the plaint, my lord, that's the reason the difference.
It's all right. All right.
Can you see the date at the left hand?
Yes, I've seen that.
Termination of passenger agency agreement default. Further to our letter, we have been advised by BSP. I pause here for a moment. This is the reason, my lord, I was indicating this BSP is not explained in this plaint. It's given in this plaint, my lord. That's the settlement system. It's also a body under IATA. That your agency has failed to settle the outstanding dues by deadline. I pause here. This is, my lord, as advised by BSP, not by Indian Airlines. This advice is given by BSP. What was being submitted, I couldn't follow, my lord, because I did not know what BSP is. Pursuant to, my lord, reading of this plaint. BSP gave an advice to IATA, being a member. This is, my lord, the settlement system by which they issue the tickets and they raise the bills. They requested for settling the outstanding by the deadline. In this regard, IATA has no alternative but to terminate.
My question is that let us take a situation that you are both of you and Indian Airlines, you are living peacefully. Let us take a situation. Absolutely no problem between plaintiff and the Indian Airlines. So the question of filing of the first suit did not arise. Let us take a situation. In that situation, can this page 68 letter be issued? Had it been a peaceful situation?
May I answer in twofold, my lord? Because I have been thinking about this yesterday and today, my lord. What is troubling me is this, my lord. Today, our entire contention in this suit is this action of IATA is bad in law.
Correct.
Had I taken this step, my lord, there could have
my
been. My
question is very simple, Mr. Wagh. First answer to that.
They could. That's because BSP has made this complaint that the amounts which were to be given, settled by us, has not been settled. It is not known whether this BSP takes cue from Indian Airlines, because this is an arrangement with the BSP. That's why the settlement
if there is no problem in between you and Indian Airlines.
My lord.
Let's take a situation.
Hypothetically, my lord, if I may answer, if there was no situation, I do not know what BSP has presumed here. But if
Correct.
BSP has presumed a dispute and then advised IATA,
And BSP has presumed a dispute between you and Indian Airlines.
that's not known. That's the problem, because today the advice given.
At least that is surfaced from the plane.
Yes,
Your first
yes,
plane.
Yes, my lord.
Your first plane.
Yes, that there was a dispute.
So why these two suits should not be tried analogously?
I'll tell you, Lordship, why. The cause of action in the second suit is completely different than
No,
the
sir.
cause of action. I'll tell you, Lordship, why.
No,
Kindly
sir.
permit me 2 minutes. I'll indicate, my lord. I'll indicate how. I'll tell you, Lordship. If your Lordship takes the next
Why
page.
should not I direct this suit
My lord.
to be tried with that suit?
Because
By
the next
treating
page,
this,
perhaps.
by treating it as a non-commercial suit.
2 reasons, my lord. It's a commercial suit. I'll indicate that right away. Right away. That will not take me more longer, because I'll indicate from the provisions.
I'm not on that.
It's
I'm
a
not on
commercial
that.
suit, my lord.
But for the purpose of justice, complete justice, because a non-commercial suit,
My lord.
to treat it as a commercial suit,
My lord.
there will be a various rigors of the Commercial Court Act.
My lord, may I only submit this? Today, if it's a commercial suit, my lord, kindly do not relegate it to a non-commercial division merely because, my lord, that the other suit is not yet a commercial suit or whatever, because there's no application there.
I want these two suits to be heard analogously.
My lord, kindly take up the next page. Perhaps I'll be able, my lord, to show, perhaps, my lord, that this is, because this next page is the letter, the complaint to the Travel Agency Commissioner, from where various facts come out, my lord.
Sir, I am convinced that both these suits to be heard analogously. I don't say that you don't have any cause of action or independent. I don't say you don't have any independent cause of action.
Because, my lord, today it has been submitted by my learned friends that if there is no sales agency agreement, how could IATA even
Mr.
with that, my lord?
Mr. Bagh,
My lord.
I am as of now, I am of the view both the suits to be heard together at a time. But the rigor in the regular suit is lesser than the commercial suit. So I will direct it to be renumbered as a general suit and to be heard along with that. I'll give my reasons why I will direct that.
Create, my lord, a few difficulties which, my lord, as of now I have to, my lord, I'll request for your lordships one day time to come back and, my lord, make submissions, because this is not something I was prepared with. Only for this reason, my lord, that today if this suit is a commercial suit, if I can satisfy that, then, my lord, I will be exposed to, my lord.
I'm saying I will not hold that it is otherwise not a commercial suit.
Understand that,
I will say, for the ends of justice,
my lord.
Ultimate achievement and goal is to achieve at the justice.
Gotcha.
The justice will be served according to me. I will give reasons.
The only difficulty then, which I'm, my lord, preempting, is this. My lord, kindly have.
What is that?
It's an order of this honorable court in this matter, my lord. On 21st June 2011, by which, my lord, it's recorded, and I'll then hand over, my lord, the appellate court's order as well, where this has been upheld. My lord, they have failed to file a written statement for 4 years. Then they approach the court. Kindly read this order and thereafter this order, my lord. Today, if it is relegated to non-commercial division, they shouldn't be getting an opportunity to, my lord, have the doors opened again.
No, but also,
that's the difficulty.
Also think of a situation
my lord,
that if these suits are really required to be heard analogously, then how will it be done?
Without, my lord, then it should be continuing, my lord, from this stage. If it is continued from this very stage where, my lord, the doors for them are closed, and that is why, my lord, in the interregnum, they had filed an application for addition of party. It was heard extensively and the petition was dismissed, because when defendant number 2 could not represent.
I will not say that this is this will lose its character as commercial suit. But for the ends of justice, it has to be heard analogously. Because at the end of the day, the two issues in the suits have to be decided.
I agree, my lord. I understand what is falling from your lordship, and
the characterization, commercial, in my view, will not stand in the way in
Very well,
such a
but
situation.
kindly peruse that order once. That's what is bothering me. Otherwise, my lord, I don't think there should be any other difficulty. This is what is bothering me, and I'll also tell your lordship. But kindly take up the commercial code side because a lot has been said.
Yes, 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 yes.
I'll only indicate two provisions, my lord, here.
Sir, I am not holding that it is not a commercial suit.
Understand that.
But
But
ultimately, while exercising my power, I will say it is for the ends of justice. It has to be done. Otherwise, it is bound to happen a conflicting justice.
I understand what is falling from your lordship.
Suppose you say you win in one suit, you lose on the other. What will happen?
I follow, my lord. That
It has to be Mr. Wag, at the end of the day, upon reading of both the plans, I'm
there's a
convinced.
connection.
I'm convinced that the trial is interconnected. Trial of the two suits are connected.
In fact, my lord, IATA could not have issued this letter at all.
Otherwise, unless
My lord.
Indian Airlines come with its stand. So that is why my question that had there been a continuous harmony and peace being maintained between you and Indian Airlines.
Not be a dispute, my lord. Then this would not come. The previous suit would
Yes,
not
that's
come.
that was my question repetitively.
But this, my lord, my endeavor is to show that, my lord, these are two.
Again, I'm saying.
If it is tried together, my lord,
Again,
analogically,
I'm
there will
saying.
not be a conflict of, my lord.
Again, I'm saying it will be for the ends of justice.
I understand.
And I have at the end of the day 151.
Indeed, my lord. My lord.
At the end of the day, I'm on
In
with
fact, my lord,
151.
my lord, may I only request your lordship to once peruse that order? Once, my lord.
I accept they have forfeited their right to file.
My lord, they have not forfeited.
The
court
law
has stopped them.
The law has forfeited.
So, my lord, if that is clarified, my lord, by your lordship, that they will not have a chance to file the written statement anymore merely because, my lord, we are being relegated to the non-commercial division and there is a direction from the honorable court that the suit.
And I will.
Because then, my lord, they will get an option.
I will give my view that it is really not on their challenge. But upon reading the plans together, side by side, I find this. Otherwise, it might happen. There will be a conflict of judicial pronouncement.
I completely bow down.
Which shall not be compromised. Which shall not be
Kindly
compromised.
protect us, my lord, to this extent that they should not get what rights they have now. They shouldn't be getting more than what those rights are as on date. Just because the matter is being, my lord, relegated to the non-commercial. And, my lord, may I only, this is only for my satisfaction, my lord. May I only request your lordship to take up the Commercial Codes Act once.
I am saying once again.
I understand that.
I
This is not a challenge.
the rigor of Order 1 by Rule 8 or Order 8 Rule 1. I accept that.
Only this, your lordship will find 21C Roman 14. Roman 14, Roman 18, first 14, my lord. It's mercantile agency and mercantile usage. It's mercantile agency, my lord, because here it's recorded in that letter which is impugned that they are agents. Agency. Sales agency agreement is an issue. Now, my lord, kindly see Roman 18. Agreements for sale of goods or provision of services. It's provision of service, my lord. That's the arrangement. Now, my lord, kindly see. The reason I was starting my submission by saying kindly look at the cause title because defendant number 2 is the insurance company. The entire challenge here is that I have taken the insurance in the name of defendant number 1. I don't want the insurance company to give it to them.
Mr. Bagh, the insurance policy would not have been invoked had there been peace maintained between you and Indian Airlines. So therefore, the parallel analogous trial is essential.
Indeed, I'm not on that. I'm only on the point that it's covered under 21C Roman 20, insurance and reinsurance, and then contracts of agency relating to any of the above. Hence, a commercial dispute. This is what I was, Lord, I would have argued on this application because this application is very limited in scope. May only beseech your lordship to give me 1 day's time. Perhaps I'll, my lord, come tomorrow and I'll request your lordship to pass this order because this is not what is exactly fallen from your lordship is what should be. Lord, unless and until I can really get something, but it is not that I get something, Lord. May I just come back tomorrow and kindly pass this order?
Correct. No problem.
Kindly permit me to come back tomorrow.
Ashu. And these two orders you supply to me, copies of these two orders
Because
and
this
the
is
appeal
where
court.
my impediment lies.
Yes, and the appeal court. Appeal court. This is the order where a right has been created in your favor to proceed against them.
I am very grateful. I am very, very
Come on. Give me the, no, duto order debe, duto order debe.
Your Lordship can keep these copies.
No, no, appeal court.
Appeal and the.
You have given both.
Both.
এই দুটোকে তুমি একটা সাদা ফাইলে রাখো, এই যে যেখানে জাজমেন্ট রেখেছো সেইখানে রাখো। ফাইল বাড়িয়ে লাভ নেই, এটা রাখো, এটা দিয়ে দাও।
And your Lordship is not deciding on the commercial aspect of it. It is only for the ends of justice, my Lord.
That's right.
Very grateful.
That's
Very
right. If possible, you can show me the law for the ends of justice, the
No,
power of
always,
this court.
Always, my Lord. Your Lordship always has that, my Lord.
At the end of the day,
I follow what is, my Lord, followed by your Lordship.
151 at the end of the day.
Indeed.
বললাম?
Right.
Pursuant to the direction of this court dated November 24, 2025, the department has produced the original plant filed in bold CS 23 of 2006. Full stop. The said record is kept along with this record, along with the record of the present suit, present proceeding, and the same shall remain as such so long the application filed in the present proceeding has not been decided finally. Paragraph. Today, Mr. Pranit Mark has commenced his submissions opposing the application. First up. He shall continue tomorrow. He shall continue with his submissions tomorrow. Full stop. Tomorrow. That is Tariq Diado. When the matter shall appear under the heading for orders.
Very deep prepared.
That is precisely that was the reason it was playing in my mind. That is why I asked you to produce the copy of the plant and I directed the department to produce. Had that suit not been there, this second suit would not have been there. So they are all interconnected. There's interconnection, interconnected issues. Thank you. আজকে লিস্ট সাপ্লিমেন্টারি করলাম তো। হ্যাঁ, তা ডাকবো ডাকবো। ভদ্রলোক এসছে? ঠিক আছে, দেখুন প্রথমে সাপ্লিমেন্টারিটা ডাকো।
Supplementary list, item number 1. Well, I'm for the decree holder.
হ্যাঁ, তো ফর্মাল আমি তো এখানে করলাম। করুন 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 করুন।
Pursuant to an order dated 17th of November, warrant of arrest was issued since he was evading service. Service was attempted on him 3 times. First, when I moved the execution application, I had served and then moved, but
What is the amount due?
Amount due is Lordship gives me a moment. Almost 50 lakhs, almost. What he does, very interestingly, he avoids service. It comes back. Just before Justice Rao, Justice Rao was pleased to direct the police, concerned police station, to file a report after finding the whereabouts. The police took the trouble, found him spoke to him over phone. He came to the police station, disclosed the address that I am not there. Now I am in Salt Lake. The matter appeared before His Lordship, His Lordship was pleased to direct me again, the third time, to serve on the new address given by him. I serve. An envelope comes back as left. It was thereafter, warrant of arrest was issued, He should be put behind bars, For at least the matter is made returnable on 27th, Let him stay, as a state guest, for the next 3 days. His conduct is absolutely,
27.
questionable.
Why it is returnable today? আমি রাখলাম কেন?
Since he has been produced before your Lordship,
হ্যাঁ, সেটা পরের কথা। তো আজকে প্রডিউস করেছে? আজকে কি কোনো প্রডিউস করার ডেট ছিল?
My lord, may I only say this? Whenever the judgment is produced, has to be produced. He's arrested, he has come to before your
Unless I direct, how can it
Yes,
be?
Today he's being arrested and it's being produced before your. I'm only praying, let him go behind bars for the next 3 days. His
All right.
conduct is
That
not
I will
fair at all.
I heard you, I will consider. First formal পার্টটা ডিক্টেশন নিন তো, কে আছে? লেখো। This is an application for execution of a money decree.
Money decree.
The decree is for a sum of rupees
43,24,255 as on the date of filing.
43,24,255 as on the date of filing of the execution application.
Appeal was also preferred, rejected.
One second. Judgment debtor is a company.
Judgment debtor.
So he is
He is the principal officer of the company.
Good stuff.
One of
Show me the appellate order.
Appellate code.
Paragraph. The decree was appealed against.
This is the Lordship gives me a moment.
এইভাবে লেখো। Mr. Deepraj Basu, DWIP, Deepraj Basu, learned advocate appearing for the
Decree holder.
plaintiff decree holder submits that the decree was appealed against. Full stop. The appeal has been dismissed by an order dated.
Order dated 16 June 2025.
June 16, 2025 by the Honorable Division Bench. Therefore, the decree has achieved finality.
No SLP file, nothing to our knowledge.
Achieved finality and the decree stands crystallized against the defendant, judgment debtor. Defendant oblique judgment debtor. Paragraph. As the principal officer of the judgment debtor, you are the director. What's your name?
Samir Kumar Ghosh. Samir Kumar Ghosh.
Ghosh. देखो, one Sri Shomir Kumar Ghosh, claiming himself to be a director of the judgment debtor company, has avoided the service of notice, comma, finally, by an order.
By an order.
It order bunch টাঞ্চ গুলো দাও। Warrant
order.
By an order dated.
I shall not immediately say. 25th September 2025.
September 25, 2025. The coordinate bench issued a direction for issuance of warrant of arrest, and to produce the said person before the court. Paragraph. The last order dated November 17, 2025 speaks for itself. Paragraph. Though the order dated November 17, 2025 shows that the matter was directed to appear on November 27, 2025, but the police authority has arrested the said Sri
Shomir
Kumar Ghosh and produced him before the office of the deputy sheriff today. Paragraph. Upon such fact being brought to the notice of this court by the office of the deputy sheriff of this court, office of the deputy sheriff, comma, the matter has been directed to be placed in the supplementary list today and accordingly has been taken up. বসুন। কি হয়েছে আপনার? পয়সাটা কিভাবে দেবেন বলুন।
আমি ফার্স্ট বলি, আমি আজকে লয়ার এই কারণে আসতে পারি।
আমার ওসব জেনে লাভ নেই, আমি যেটা প্রশ্ন করছি তার উত্তর দিন।
27 আমি অলরেডি এফিডেভিট অফ এক্সিকিউশন জমা করছি।
আমি বলছি আপনি কিভাবে টাকাটা দেবেন সেটা বলুন।
বলছি মাই লর্ড, আমি 27 অলরেডি জমা করছি।
আপনার অ্যাফিডেভিট দিয়ে আমার শোনার দরকার নেই, আপনি কিভাবে টাকাটা দেবেন বলুন, নাহলে আজকেই আপনি জেলে থাকবেন।
আমি কয়েকখানা ইনস্টলমেন্টে ডেফিনেটলি।
ইনস্টলমেন্ট পরে কত টাকার ডিক্রি?
অ্যাকচুয়ালি বেসিক অ্যামাউন্ট ছিল 23 সামথিং।
বেসিক অ্যামাউন্ট, ঠিক আছে, আপনি 25 লাখ টাকা সামনের সপ্তাহে জমা করুন।
বিজনেস এট দিস মোমেন্ট বিজনেস ইজ।
আমার জেনে দরকার নেই, টাকা যখন ডিউ ডিক্লেয়ার্ড হয়েছে আপনাকে টাকা দিতে হবে। সামনের সপ্তাহে 25 লাখ টাকা নিয়ে আসুন, বাকিটা আমি ইনস্টলমেন্ট দেবো।
পসিবল হবে না। লেট মি কমপ্লিট।
তাহলে আপনি ভেতরে থাকুন।
লেট মি কমপ্লিট এট লিস্ট। আমি 27 আমি আগে এক্সিকিউশন অফ এফিডেভিটটা জমা করি ওখানে।
ঠিক আছে, আপনি ভেতর থেকেই জমা করবেন।
Let me complete, sir.
Let me kindly see the conduct, the way he's speaking.
No.
Let me complete, sir. ওখানে মোটামুটি অ্যাপ্রক্স আমার 10 লাখের মতন চলে আসছে, যেটার মধ্যে।
I don't believe in all those. I want to see the color of money. সামনের সপ্তাহে 25 লাখ টাকা জমা করুন। কিভাবে কি আসছে কিভাবে কি যাবে আমার জানার দরকার নেই। আপনার যদি সামান্য বনাফিটে থাকতো, ডিক্রিটা হারার পর অ্যাপিল কোর্টে আপনি এসেই কোর্টকে বলতেন হুজুর আমি ইনস্টলমেন্টে দেব, জমা করব।
আমি এক্স্যাক্টলি জানতাম না, একটা অলরেডি
আপনার এখন জানতে হবে একটাই, আপনি টাকাটা সামনের সপ্তাহে 25 লাখ টাকা দেবেন।
স্যার সামনের সপ্তাহে না করে মাই লর্ড, ডিসেম্বর পর্যন্ত মাই লর্ড।
25 লাখ টাকা সামনের সপ্তাহ,
ডিসেম্বর 15 পর্যন্ত।
সামনের সপ্তাহে 25 লাখ, তারপর আপনাকে আমি ইজি ইনস্টলমেন্ট দেব।
ডিসেম্বর 15 পর্যন্ত মাই লর্ড কিছু করুন।
সামনের সপ্তাহে 25 লাখ, তারপর আপনাকে আমি ইনস্টলমেন্ট দেব, বলছি তো।
কিছু করুন মাই লর্ড।
25 লাখ টাকা সামনের সপ্তাহে। Mr. Sengupta, have you seen the judgment? I pronounced it yesterday. I have dismissed your application. Sorry. It's on the server. You can go through it. সামনের সপ্তাহে 25 লাখ, তারপর ইনস্টলমেন্ট দেবো।
আর কিছু টাইম
সামনের সপ্তাহে 25 লাখ, বলছি তো 50 লাখে 25 লাখ সামনের সপ্তাহে,
একটুখানি
তারপর আবার দেবো। আমি টাইম দেবো, 25 লাখ জমা করুন, ঠিক আছে?
ঠিক আছে মাই লর্ড, আপনি সামনের সপ্তাহে ফুল উইকটা টাইম দিন, এট লিস্ট।
হ্যাঁ,
ফুল উইকটা টাইম দিন নেক্সট উইক।
আজকে কত তারিখ?
আজকে 27 তারিখ।
24th,
হ্যাঁ,
25th,
24
কি বার?
আজকে 25th,
সামনের মঙ্গলবার 25 তারিখ।
ফ্রাইডে করুন, এট লিস্ট ফ্রাইডে পর্যন্ত, আপ টু ফ্রাইডে করুন।
25 লাখ সামনের মঙ্গলবার,
grateful.
সামনের মঙ্গলবার 25 লাখ। আসুন। Somir Kumar Ghosh has been placed in the dock. Wherefrom he has undertaken specifically to pay a sum of rupees 25 lakhs. আপনি ডিপোজিট করুন রেজিস্ট্রারের কাছে 25 lakhs. কি বললাম? Sum of rupees 25 lakhs with the learned registrar, original site. সামনের মঙ্গলবার কি তারিখ হচ্ছে? By December 4, 2025, বৃহস্পতিবার। বৃহস্পতিবার, December 4, 2025. Full stop. The judgment debtor prays for some installments, such prayers shall be considered on the next day upon the said sum of rupees 25 lakhs being deposited with the registrar original site. Full stop. The matter shall appear under the heading, না এটা কিসে আছে? Under the heading to be mentioned for the purpose of recording compliance of today's direction on কবে দিতে বলেছি? 4 তারিখ। হ্যাঁ, তো লিখুন টু বি মেনশনড 8 তারিখ, December 8, 2025. Paragraph. In the event the said sum is deposited, in the event after the said sum being deposited, the registered original site shall keep it in an interest bearing shall hold it with him till the next date when the matter shall be taken up for further consideration. Then I shall direct
Since
for
the
release.
appeal has already been dismissed, my lord, and he has.
I will direct the
Lordship.
post of paragraph. ঠিক আছে। It is pertinent to note that this direction for deposit is meant towards pro tanto satisfaction of the decree.
Satisfaction.
Towards pro tanto satisfaction of decree.
But only this, my lord, as and when required, my lord, he should be present before your lordship. An undertaking should be given.
He will be present. He will come to court.
Should give an undertaking.
Paragraph. Sri such and such has also undertaken to be present personally when the matter shall be taken up next on December 8, 2025.
Grateful.
Full stop. In view of the above, the petitioner, the Sri such and such is not required to be arrested for the time being. However, whenever he is required, if in the meantime he shall full stop. However, in the meantime, every day he shall record his attendance before the local police station. By 12 noon every day.
12
My lord.
The local police station is Chitpur.
সমীর ঘোষের সঙ্গে সেও কি ডিরেক্টর?
One of the principal officers, as per the RSC.
Actually, what happened? Minimum 2 directors are required for the private limited company. That is why my father with the.
Doesn't matter. টাকাটা দিয়ে দিন, কিচ্ছু যায় আসে না, যতজন খুশি ডিরেক্টর থাকুন।
ঠিক আছে।
হ্যাঁ, আপনি পরের দিন 25 লাখ টাকা জমা করুন, আপনাকে আমি ইনস্টলমেন্ট আপনার প্রেয়ার আমি শুনবো।
My lord, 12 noon যেটা আছে ওটা at least morning করুন either or evening.
By 9 AM every day. সকাল 9টা। By 9 AM every day.
The Chitpur police station, the local police station is Chitpur.
Wherever. দাঁড়ান।
বিধাননগর থেকে অ্যাড্রেস করেছে সল্লে। He had said that he resides in Salt Lake, so that should be Bidhannagar police station. He had said that he resides in Salt Lake, so whatever local police station. Wherever.
Now, which police station has arrested him? Bidhannagar.
That's what
local police station. Local police station.
Local police station.
Where from? Likun. Where from? He has been produced today.
Yes, sir.
Now, local police station by name বাস ঠিক আছে আর কিছু লোকাল পুলিশ স্টেশন which has produced him today by 9 a.m. comma which has produced him today. আচ্ছা নেক্সট কে আছে নতুন? ইয়েস আর কিছু বলবেন আপনি? নেক্সট ওনাকে ওঠান।
চিঠির কথাটা বললেন না আজকে দিতে, আমরা তো এখনো বাড়ি যাইনি।
আপনি কি ডিরেক্টর?
না, আমি এই বয়সে 85 বয়স।
একটু মাইকটা ধরান ওকে, বলুন কি বলবেন।
ডিরেক্টর নেই আমি।
হ্যাঁ,
আমার কোনো ডিরেক্টর হিসেবে নেই।
আপনি ডিরেক্টর নেই?
এখন আর নেই, আমি তো কি করব।
আচ্ছা ঠিক আছে। The other gentleman, next paragraph, namely Sri
রবীন্দ্রনাথ ঘোষ
Robindranath Ghosh has also been produced before this court today, who is the father of Sri Shomir Kumar Ghosh. কিছু বলবেন আপনি?
না, ওই চিঠিটার কথা বললাম।
হ্যাঁ,
চিঠিটা বললেন না দিতে, লোকাল থানা
চিঠি দিতে বলেনি।
ও চিঠিতে বলেনি। ধন্যবাদ।
full stop. He has also produced full stop. Paragraph. Considering the age and health of the said Sri Robindranath Ghosh, who appeared personally today, his personal presence on the next day stands dispensed with. However, his son, Sri Shomir Kumar Ghosh, every day shall inform the police station, concerned police station, about the whereabouts of his father. The concerned police station shall keep note of it. ঠিক আছে, সরিয়ে দাও।
Grateful.
Thank you.
Grateful.
হ্যাঁ, যা চলছে চলো। আপনি পরের দিন 25 lakhs দিয়ে দিন, 25 লাখ দিন। I will consider for your prayer for installment.
Chamber application for final disposal, item number 11.
Just in the dock. DOCK. এটাকে ডক বলে বাক্সটাকে। অরিজিনাল সাইড কাজ করছে, অরিজিনাল সাইড রুলস পড়েছো?
এই অর্ডার শিট নিকালো, অর্ডার শিট।
উইটনেস বক্সটা হচ্ছে সাক্ষীর বাক্স, তো কলকাল কথা, আসলে ওটাকে বলে ডক।
দুটো অর্ডার দাও।
আমাদের ক্যালকাটা কোর্টের ক্রিমিনাল সাইড হ্যাজ a very rich history and very very rich culture.
ইলেকশন ছিল না,
রুলস থেকে বোঝা যায়। ঠিক আছে,
ওটা আমার কাছে ফিজিক্যাল কপি নেই, বাট ওটার মধ্যে
আমাকে ডেটটা বলে দাও।
24 সেপ্টেম্বর।
yes,
Lord, I'm
এটা কত নম্বর? 11. Yes, 11.
Lord, this is an application filed by my client, my lord, who was in course of pendency of the execution proceeding, my lord, was inducted as.
Anybody is opposing?
They are not.
What is the
appearing,
application
my
for?
lord, they are not appearing, my lord, after filing of this application, my lord.
Who-
They are by direction,
What
my
is
lord.
this application for?
But there are two applications, my lord. One application, my lord, is the first application is GA2, GA2, my lord, I'm challenging. There, my lord, I have twofold prayers. First
What is
one,
GA2?
yes, GA2, my lord, there, my lord, I have made twofold prayers.
No, you're asking for dismissal of execution proceeding.
Yes, dismissal.
You are appearing for defendant.
No, my lord, I was not a party to the suit. The decree was, money decree was obtained, my lord, against a firm, allegedly a partnership firm. I was inducted in execution proceeding by a oral submission made made by the bar, and a warrant of arrest was issued. And my lord, is this how my lord, I wrote in the proceeding, alleging that I'm current partner of the firm.
All right.
So
What is the other application?
The other application, my lord, I have sought, my lord, recalling of 2 orders where, my lord, affidavits, direction for filing affidavits
Orders,
were given.
nature of order?
My lord, I was produced, my lord, I was put on terms to make certain deposit before the learned register. My lord, that I have deposited, and my lord, my bank account has also been attached by that order.
So you have deposited. How much?
Yes, I have deposited because
How much?
My lord, 4 lakhs.
What was the decree?
My lord,
amounted
decree
for?
was passed, my lord, by a Delhi district court for a sum
Okay.
of for a
Sent
sum of.
for execution. What was
My
the
lord,
name?
here there is
What is
another
the
issue.
quantum of the decree?
5,50,000
And 4 lakh is
interest.
deposited.
plus interest.
4 lakh is deposited.
4 lakh, my lord, I deposited because I was arrested. I did not have any choice, my lord. So thereafter, my lord, I took out an application. I said that I'm.
Serve the decree holder and come back.
My lord, there was a direction, my lord. They are not appearing, my lord. Kindly, your lordship sees the order dated September 15. Thereafter, my lord, even prior to that, my lord, multiple occasions matter appeared. I spoke to Mr. Shaunak Mukhopadhyay also, my lord, who was appearing, my lord, for the decree holder at some point of time, my lord. They
Unless they come, no order can be passed. Ashud.
My lord, on September 15, my lord, there was an order. It was recorded by His Lordship Justice Rao that in the event if they don't appear, the appropriate order will be passed. And my lord, in GA3, my lord, multiple directions were given to file affidavit in opposition to my application. They did not file. My lord, I will serve them again, my lord, if your lordship, but my lord, kindly record this.
Let me be very candid on the issue.
Yes, my lord.
The moment the amount has been deposited, I'm not going to release it. Because after all, a decree is there.
My lord, kindly consider.
After all, a decree is there.
My lord, I am not connected with the firm.
Correct. I am.
Whatsoever.
That is why I am not dismissing your application right now without hearing them or not passing any order, any further order.
My only
But
case
the
is
amount I will not
the
release.
first onus lies upon the decree holder to demonstrate that whether I'm a beneficiary of the asset or I'm.
Agreed.
Yes.
Totally agreed.
No.
Totally agreed. That's why I am not passing any adverse order against you.
Yes.
But I will not release the amount unless I hear them. So long if they will not be heard, your amount will lie.
My lord, if they don't come,
So long I am here.
My lord, if they don't appear, my lord, because my lord,
Mr. Counsel, this is a commercial court.
my lord, I have raised this issue.
Maybe it sometimes may be worse than the Shylock.
My lord, this issue has also been raised. My lord, kindly consider.
I appreciate.
It cannot be a commercial.
I appreciate. No, it is in execution.
No, 2011 transfer decree passed. Transfer decree ordered. And they file a fresh execution application.
Whatever, sir, I am not going to release. It will lie. I am not going to direct to pay somebody. It will lie under the safe custody.
Yes, it is lying, but my lord, allow me to operate my bank account at least. 4 lakh has been deposited.
Let's see.
I can't operate my bank account.
Let's see. I do not know. Let them appear then. Or I don't mind if you go and if you get a settlement of decree with your.
Them? My lord, I don't have any connection with the firm.
Chalo. Ashud.
I'm not bound by the decree.
This is 11 তে একটাই জিয়ে আছে
11 and 12. 12
আচ্ছা
is the other GA, same matter.
11 and 12 একসঙ্গে অর্ডার করে দিন। These are the interlocutory applications taken out by one Sri
My lord, my client's name is my lord ki bolo na.
Surya Kumar Pandey.
Surya
Surya Kumar Pandey.
Surya Kumar Pandey, my lord.
one Sri
My lord, Surya Kumar Pandey.
SURYA
SURYA.
Kumar
Surya
Pandey
Kumar.
Surya Kumar Pandey
Yes.
paragraph. He claims that he was no way connected with the judgment debtor and has been entangled in the execution proceeding. Pursuant to the direction, paragraph, pursuant to the earlier direction of the coordinate bench, he has also deposited a sum of rupees 4 lakhs.
Total 4 lakh as of now.
4 lakhs with the registrar original side of this court. And the same is lying as such. Paragraph. None appears for the plaintiff decree holder. Paragraph. The applicant shall serve notice along with a copy of today's order upon the plaintiff decree holder, intimating the next date of hearing. এই শোনো বাবা, ওই প্রিন্টারের উপর ওরকম ভারী জিনিস রেখো না। প্রিন্টারের উপর কোনো জিনিস রাখবে না। পোস্টার। However, if despite notice none appears for the, if despite notice the decree holder is not represented on the next day, the court may consider the prayer of the applicant at least to the extent of lifting an injunction, lifting the order of injunction insofar as his bank account is concerned. ঠিক আছে। The matter shall appear under the heading Chamber Application for Final Disposal on January 15, 2026. Acha, or petitioner shall file affidavit of service on the next day.
My lord will only consider lifting of.
Deposit, I have no point.
My lord, I should be discharged from the proceeding, my lord. That is my prayer.
Let us consider.
कुछ डॉक्यूमेंट हम लोग उसमें एनेक्स नहीं किए थे तो वो वाला
My lord, I had prepared, my lord, a supplementary affidavit, my lord. There were few documents, my lord, were not erroneous.
On the prayer of Mr.
Asif Hussain.
Asif Hussain, learned advocate appearing for the applicant, comma, leave granted to file supplementary affidavit, full stop. The supplementary affidavit filed in court today is taken on record, full stop. Copy shall be served upon the decree holder.
Yes, served. We will serve again. Grateful.
Comma, if not served earlier. Next.
Grateful.
If not served earlier.
Grateful.
Comma plot. Next.
Item number 13. Making metal certificate.
13 and 14, I'm appearing for the defendant number 2. But I'm in some difficulty, my lord. I'm in some difficulty. The junior of the advocate on record, my lord, she has left services of the firm. She's moved out. My lord, some of the pleadings in GA1 and GA2 filed by some of the pleadings, my lord, GA1 filed by them, GA2 filed by me, pleadings completed in both. That is there recorded, my lord. Their orders 12 rule 6 and my 7 11.
Want?
Sir, I want an adjournment, my lord. The junior, I don't have all the pleadings with me.
Only
We
one
are
thing.
trying to ascertain the.
You are opposing the execution.
No, this is, my lord, their suit.
What is the chamber for?
The
What is the chamber summons?
They filed, your lordship, for dismissal of the suit.
Order 7 rule 11 and their.
Order 7. Why? You don't have to worry. There is no order of injunction, nothing.
No, I am for the plaintiff. Your lordship, there is an order of injunction.
What to
against them.
extend? That's in your favor.
It is my favor, but my application is for judgment upon admission. Admitted claim, your lordship, they have issued a check which was dishonest. Now, your lordship, so that
And judgment upon admissions affidavit filed.
yes. Now, what happened, your lordship, only to stall my application so that it can further proceed. They filed an application for dismissal of the suit.
All right. Wait for some time.
I was praying, my lord, lordship can hear both the application. Lordship keeps it anytime.
If I will hear the dismissal, then the judgment upon admission. If the dismissal succeeds, matter ends. If the dismissal does not succeed, then on the judgment upon admission.
My lord.
Ashu.
Lordship keeps it anytime as per my lord's convenience. Will come, my lord.
কি বললাম 13-14 একসঙ্গে অর্ডার করুন IAGA কম
His is 1, mine is 2.
IAGA com 1
of your lordship 2021.
2021 is an application filed by the plaintiff praying for judgment upon admission. Full stop. Affidavits are complete. Paragraph. IAGA com 2 of 2021 is an application filed by defendant number 2 paying for rejection of plaint stroke dismissal of the suit. Full stop. Affidavits are complete. Mr.
Shashwat Nayak, my lord.
Shashwat
Nayak, my lord. NAYAK.
Nayak, NAYAK, learned advocate appearing for the defendant applicant and applicant লেখার দরকার নেই, appearing for the defendant number 2 prays for an adjournment of the hearing. Full stop. Paragraph. Rest of the defendants are not represented.
We are only for 2, my lord.
Huh?
We are only for defendant number 2.
The rest are not represented. Full stop. Mr. Subhashish Sengupta, learned advocate appearing for the plaintiff, has opposed the prayer for adjournment. Paragraph. However, for the ends of justice, the adjournment is granted. Both the applications shall appear under the heading Chamber application for final disposal, one after another, on আজকে কত 25 December 16, 2025. Paragraph. It is made clear that on the next day, no prayer for adjournment on behalf of the defendant shall be exceeded. It is made clear that on the next day, the prayer for adjournment দরকার নেই ছেড়ে দিন। চল।
I'm extremely grateful, my lord.
One thing, your lordship, should I give notice to one? Should I give notice to 1 and 3? The reason is he's for the 2. So kindly give me that liberty, your lordship, so that
Plaintiff shall serve notice upon the non-appearing respondents along with a copy of today's order.
And indicate the date of the hearing.
Along with copies of today's order. Upon the non-appearing defendants along with a copy of today's order and shall file an affidavit of service when the matter shall be taken up next. এটা কি বিল?
I'm grateful.
15.
My lord, I appear for the plaintiff in this matter, my lord. My lord, this is an application much in the nature of demurrer, my lord, taken out by the defendant number 1.
You are for the plaintiff?
Yes. The defendant number 1 was the only entity which was appearing before your lordships, my lord. But thereafter, the defendant number 1 has suffered CIRP, corporate insolvency resolution process. The rest of the defendants have not been appearing. So, my lord, it was their application. Perhaps.
So what shall be the proposition of law?
Well, the RP ought to
Yeah.
have moved it. If the RP does not move it,
RP will have to be substituted.
yes. But now, my lord, we have not received any formal communication from anybody as of now. We are not parties to the CIRP process.
Okay.
Now, we have also not received any communication insofar as the commencement of CIRP is concerned. So, my lord, perhaps it wouldn't be proper, my lord, until unless I'm served with a copy of the order, or at least, my lord, any communication from the part of the defendant number 1. Perhaps I wouldn't be able to move in any event, my lord, there's a moratorium, I won't be able to move. But nonetheless, my lord, at least I could have taken steps to effect the substitution. But at this juncture, perhaps I wouldn't be able to do that either. Now, my lord, insofar as the rest of the defendants are concerned, my lord,
So in that event, you have to come up with a small application. If you can get the records of the IRP or whatever, CIRP proceeding,
the final order, my lord.
whatever.
But my lord, I do not know because
Just to appear for the defendant number 1,
yes, but
they
there was
have it is a confirmed CIRP order, confirmed up to.
So that's all right, but something has to be on record.
that is the difficulty. My learned friend was there on behalf of the defendant number 1.
So Anjani, I'm keeping it in February.
Very well. Now, my lord, this was again, my lord, much like the earlier one. There was this demurrer application was filed by the defendant number 1 to stall my application for judgment upon admission. Now, my lord, that matter is appearing as item number 25.
No,
Very
you come on that day.
Very
Come on that day.
Very well.
Item number
5, my lord.
Very well. দুটোতেই order করে দাও. This is serial number 15. 15 or 25. ও না, এটা তো আবার new application. এটা তো
My lord, affidavits have been exchanged, yes.
এটা চেম্বার, দুটো আলাদা আলাদাই হোক, কিচ্ছু যায় আসে না। এটা করুন অর্ডার 15, হ্যাঁ। মিস্টার জয়ন্ত সেনগুপ্ত learned counsel appears for the plaintiff. Paragraph. None appears for the defendants. How many?
Well, there are 7.
So plural.
Plural.
Naturally has to be defendant number 2. Defendants. Paragraph. He submits that he has gathered informations. He submits that the plaintiff of late has come to know. How many plaintiffs?
My lord, there's only one plaintiff, my lord.
Plaintiff of late has come to know that the first defendant has gone under the process of insolvency under IBC. Full stop. Hence, the resolution professional appointed to represent the defendant number 1 by virtue of operation of law. Paragraph. Since the defendants are not represented, no record has come before this court to that effect. And the plaintiff has also not been able to produce the same as of now. Comma, as the plaintiff is not a party in the insolvency proceeding. Paragraph. In view of the above, this application of the plaintiff, this application for the defendant number 1, this application filed by the defendant number 1, praying for rejection of plaintiff.
for striking out deletion of the name of the defendant number one, effectively for deletion of the name of the defendant number one.
Application 1, praying for deletion of its name from the array of the defendants shall appear on February 19, 2026. ঠিক আছে? Under the heading Chamber Application for Final Disclosure. Paragraph. The plaintiff, in the meantime, shall be at liberty to take steps in accordance with law. Chalo, next.
Item number 16 is my application for execution, Your Lordship. And the last order, if Your Lordship.
This is?
Execution application.
Money decree.
Money decree. Actually, an interim order for securing a certain sum. Interim order executable as a decree. For that, an execution application had been filed by me. If Your Lordship takes the last order, under Section 36, it can be executed as a decree because they have not been complying. September 15, 2025, Your Lordship. The last order.
What happened to a warrant?
We have done the needful. We have lodged the warrant with the sheriff for its execution.
So I'm calling upon a report.
Yes, we were informed that the report perhaps is with Your Lordship. And in this particular case, the respondent has never appeared. Even the service upon the respondent was a substituted service through the process of the court.
Which is the local police authority?
Local police authority, we have given the details. Pukuria Police Station, address, Post Office Pukuria, District Malda, Ratua 2, Malda District, West Bengal. I have given the details and particulars. With the challan.
Ashun. The last order of.
I'm sorry, may I hand up a copy? May I also hand up a copy of that report? Of us lodging the warrant for execution. That is the original.
I want that particular of the police station.
It is there. It is there.
কি বললাম? বলিনি? লিখো। The last order of the coordinate bench dated September 15, 2025. না তার মাথার উপর। This is an execution application arising out of a money decree dated.
Money decree dated, Your Lordship. Money decree dated 25th August 2024.
August 26, 25. August 25, 2024.
5th August.
Oh, August 5,
5.
2024. August 5, 2024. For a sum of rupees?
For a sum of rupees, for securing a sum of rupees,
Why
14
securing?
lakh, 14
Decree
lakh
for
93.
securing?
Because this was an interim order. Interim order for security, which I'm seeking to execute.
Then it is not a decree.
It's not a decree.
কি বললাম?
It's an interim order for security executable as a decree.
No, this is an execution application arising out of an interim order. Interim order dated such and such, directing the defendants. How many defendants?
Only one defendant.
Directing the defendant to secure a sum of rupees
1493. 14,93,627.
14,93,627. Poster. Paragraph. Mr. Kumarjit Banerjee, Learned Counsel, appearing for the plaintiff, submits that since the defendant defaulted in securing the sum, the execution proceeding has been initiated, in which the coordinate bench on September 15, 2025 passed an order for issuance of warrant of arrest, as the defendant is not represented at any point of time. The defendant has not been represented at any point of time. Paragraph. The report of the Office of the Deputy Sheriff dated November 4, 2025 shows that the defendant warrantee remained absent from his respective house to evade police arrest. Paragraph. In view of the above, the concerned police station being Pukuria Police Station, PUKHURIA, পুরোটা বোল্ড করে দেবেন, হ্যাঁ, পুকুরিয়া পুলিশ স্টেশন, পিক্যাপ পিক্যাপ এসক্যাপ, ঠিক আছে, পুরোটা বোল্ড। In view of the above, করে করুন, the officer in charge, এই অফিসার ইনচার্জ থেকে বোল্ড শুরু হলো, কমা পুকুরিয়া পুলিশ স্টেশন is directed to produce the defendant before this court on the next day. এটা ফেরত দিয়ে দিন তো কুমারজিৎকে। Paragraph. The matter shall appear under the heading chamber application for, why it is final disposal? Affidavit directed.
Affidavit has not been directed because the defendant never represented himself.
Represented himself?
He never represented.
Never. Shall appear under the heading chamber application, new chamber application. New chamber application on January 8, 2026. Paragraph. The office of the Deputy Sheriff of this court shall communicate this order to the officer in charge of the concerned police station as indicated above. Full stop. The plaintiff shall carry out all necessary formalities in this regard forthwith. Paragraph. The plaintiff shall also serve a copy of today's order at the concerned police station and file an affidavit of service on the next day. Ashu.
Deeply obliged, Your Lordship.
Next.
Your Lordship, I am appearing on behalf of the plaintiff. Your Lordship, I am led by Mr. Ishan Saha in this matter.
The fourth day when they are seeking an accommodation in his application.
Uh-huh.
This is the fourth accommodation being sought for in his application for extension of time to file written statement.
Do it.
Your Lordship, let Mr. Saha state whatever he wants.
What he has said, kindly listen. Take the microphone, sir.
Yes, Your Lordship.
দেখি কাগজটা দাও। Within 120 days.
I dispute that, my lord.
Mr. Ghosh?
No, it's not within 120 days.
Not within 120
No, my lord.
days.
Your Lordship, I am not brief in this matter, Your Lordship. This will be prejudicial to our right. Your Lordship, last time if we can be awarded, if we can be given the adjournment, Your
This
Lordship.
is the fourth occasion.
Your Lordship, on the last occasion, the defendant also
Take
sought
the
for
microphone.
adjournment.
When you rise, he can adjournment.
Defendant also?
Are taken for adjournment,
No, no.
Your Lordship.
That's right. So this time you must do.
Your Lordship, this would be the last
do it.
time if it can be done, Your Lordship. Let Mr. Saha state what he has to do, give in the matter, Your Lordship.
Your other side is opposing because today is the fourth adjournment you are praying for.
Leave
So do it.
the court, Your Lordship. My senior would be.
Give me the date.
Your Lordship, leave of the court. For, my senior is here, Your Lordship.
So what?
Want to take leave of the court for my senior to proceed in the matter, Your Lordship.
I'm granting you leave. Oh, acha. Yes. Do it, ma'am.
Lordship, just two things, my lord. If your lordship kindly takes this, the relevant list.
Has it been done within
Yes,
120
within
days?
120 days, it's within 90 days. It is post
30 plus 90?
No, 30 plus. No, it's within 90 days. 30 plus 88 days.
Show us. Show me.
Lordship, I'll just give you the list of dates. My lord.
Report of the sheriff is there for serving summons on account of writ of summons. Yes, any report is there?
No,
This is appearing for the first day.
It appeared previously as well.
Rather moved for the first day. Ashu. Considering this is an application praying for extension of time to file written statement in a commercial suit. This is an application filed by the which defendant?
Lordship, this is plaintiff petitioner.
Reply to the counter.
Lordship, I'll just indicate. We have filed a plaint to which they have filed a written statement as well as a counter claim. So for the counter claim, I'm filing this written statement.
What is then again 30 plus 90?
Lordship, I'll indicate two things, my lord. On 2nd of April, this was affirmed. On 3rd April, it was filed.
When you have received the counterclaim, when you are served with the
In 6th of January, my lord.
So let us take the list of dates. So long none of us will dispute on the dates. Let us read those. So 6 January 25, written statement with counterclaim was filed on behalf of the defendant.
Lordship.
No doubt about it. Mr. Ghosh?
Yes, my lord.
No dispute?
No dispute.
3rd April. So the 30 days expires on?
5th of February. In fact,
5th of March.
30 days, my lord.
30 days, my lord. 5th February.
Sorry, 30 days. 5th of?
February 2025.
So how could you pay for leave on 3rd April after a month almost?
Lordship, your lordship takes.
Very well. Very well. Plus 90 days. So 90 days expires on 90 days?
January, February, March, April. Lordship, 5th of April 2025.
Leave granted on that day?
Lordship, leave was granted.
Show me the order.
It was on 11th of August, which was recorded that leave was granted. Because on 3rd, 2nd, it was mentioned where the court.
No, madam. 3rd April matter was mentioned. Take the list of dates. Correct.
Sought leave of this lordship.
3rd April matter was mentioned.
Lordship, it was mentioned, it was granted, it was indicated in that written statement, original written statement, that endorsement was there.
That's right. The original written statement ache.
There's a direction of the previous coordinate bench of August 11 is the written statement on record. That's paragraph 6 of the order at page 2. Possible order.
Ask her to come. I don't know the dates. Ask her to come. Tell the matter is taken up.
In the meantime, read on. Read on.
In the meantime, Office of the Master is directed to place the written statement to the counterclaim filed by the plaintiff on 3rd April on the next date fixed. Affidavit in opposition, that is GA2, list on 19th August.
To place the written statement before the court.
Yes.
Before the court.
Yes.
So the written statement must be on record.
Yes. Because
Judge Sahab's order ache.
There's a is not the court.
Come tomorrow. Let the written statement come. Passed over. এইটা এখানে এটা একটা ফাইলে রাখো, ভুলিয়ে না যায়। এটার সঙ্গে অর্ডারটা রাখো। Next.
Only one thing, my lord. We'll take inspection of the written statement once, my lord, because there's a substantial issue involved in this.
Let it come.
Yes, my lord. We'll take it tomorrow.
Before doing the matter, you take inspection here.
My lord, probably I'll have to take your lordship's leave for that.
When the matter will be called
I'll
out,
take it then.
you remind me, I will grant you.
Lordship, I'll do that. Great.
Second number 18.
Yes.
This is my application.
Opposing the application.
Oh?
My friend is supporting.
Opposing the application.
Like my
proposing.
Opposing
the application. Well, you can record that and dispose it. Well, this is an application under section 8. I had commenced my arguments about a week back. Section 8.
Proceed.
I'm the sole defendant. I've taken out an application under section 8, ostensibly under section 8 of the Arbitration Act.
5 and 8.
Yes. I've sought dismissal of the suit. That's my primary prayer. But also in the alternative, my lord, in my pleading,
you can pray for dismissal of the suit. You can pray for reference before the arbitrator.
My lord, in my master summons, this is a point which will be argued by my learned friends. And in the master summons, I've sought rejection of plaint on the ground of the suit being barred, since there's a binding arbitration clause. Section 5. In essence, section 5 is my argument. But in my pleadings, my lord, while considering an application.
Doesn't matter. Don't be so technical.
My lord, that is exactly
if
what.
If you succeed on section 8 plea, the parties will be referred to arbitration. Matter ends.
My lord. That's all. That's essentially my case.
Yes.
Well, I will recall I had placed.
Show me the plaint.
Yes. Mullah, if Mullah takes GA2.
And you have read my judgment, the last one I have delivered yesterday or day before it has been served or placed on server.
I'll check.
On section 8.
Mr. Rajoshi Dotto was arguing for it.
Yes.
I'll check, Mullah. I'll check. I'll get the judgment.
IAGA Com 4 of 2024. CSCOM 652. CSCOM 652 of 2024. Dated 2011. 2025.
We'll check that.
Yes, you place your argument.
Right.
My lord, the plaint I had taken, my lord, two once. I'll just quickly recap. My lord,
Take
if
the
my lord takes,
microphone properly.
yes, my lord. If my lord kindly takes GA2, that's my application.
Decision है ये.
Yes, my lord. Last occasion I had cited one decision.
Let's see the plaint.
Yes, my lord. GA2, if my lord has the application, page 41 is the plaint. Page 41.
Yes.
My lord, here there are only 2 or 3 paragraphs I want to refer to.
Wait.
Man.
Yes.
Lord, we'll see the plaint. I'll just refer to the relevant paragraphs. Page 43, paragraph 6.
You are the defendant.
I am the sole defendant.
Page 40?
43, paragraph 6. Lord, will. I'm sorry.
Yes, read on.
Yes, Lord. Paragraph 6, Mullah, there's reference. The entire paragraph is not relevant. There's a
read on. No problem.
Fine.
Defendant by letter.
The defendant by letter of sanction dated 28 February 2018, a copy whereof is annexed here to and marked with so and so, have inter alia granted sanction of the loan to the tune of rupees so and so as sought for by the plaintiff. This was followed by execution of a loan agreement.
And sought for the plaintiff. And sought for
or by the plaintiff.
This was followed by execution of a loan agreement 28 February.
Yes.
Show me page B, annexure B, which page?
Yes. Annexure B, my lord, will kindly directly come to now the loan agreement here. This is the plaint without annexures. I have annexed the loan agreement separately. Page 9. My lord has to go. Page 9 is the loan agreement. Here the arbitration clause directly, my lord, will come to.
1 second.
I'm sorry.
Yes.
Page 9 is the loan agreement.
Page 32.
Directly, my lord, page 27, my lord. 32 is also relevant, 27 before that. Page 27, clause 22.
Acha.
Clause 22A. If any, I'm sorry, may I please, my lord?
Yes.
If any dispute, disagreement, difference arise between the parties includes both the parties herein, including any obligers during the subsistence of the loan documents.
Or thereafter.
I had indicated that, Malal will recall.
And not thereafter.
Exactly. And or thereafter, in connection with inter alia validity, interpretation, implementation, alleged breach of any provisions of the loan documents, jurisdiction, existence, appointment of arbitrator.
All right. Show me what is the cause of action in the plaint.
Yes, Malal, only at page 27, one more thing. Malal will see the 4th line from the bottom. Place of arbitration from the bottom. Place of arbitration shall be New Delhi. Malal finds that. 4th line from the bottom at page 27. Place of arbitration, New Delhi. I'm just indicating that because that is also a point I've taken. That if at all, the plaint would not be maintainable here. Jurisdiction solely vested in New Delhi court.
No.
Yes.
That's for arbitration.
Arbitration.
Seat of arbitration.
Yes, I've taken that jurisdiction, territorial jurisdiction point as well in my application. Arbitration clause number one.
How could you?
Well, because today the arbitration clause says the seat of or seat, venue, place of arbitration is New Delhi. They could not have come before this honorable court with any action, even under section 11 or otherwise.
Counsel.
Right.
If you can show it's hit by 8, 5 and 8, matter ends.
Right.
Thereafter, wherever the arbitration
Right.
will be held,
Right.
that's not the business of this court.
Right.
Yes.
Thereafter, my lord.
That may come at the section 9 stage.
11,
Or
section 9.
11. That's right.
Yes.
Yes.
My lord, then the schedule of the, since that is falling from my lord, I don't think then
Show me that what is the dispute in the plaint.
Yes. Then my lord will kindly come back to the plaint. Page 41 it starts. I'll just place 3 paragraphs to show that this is a part of the cause of action, or rather the cause of action wholly arises out of the loan agreement and is covered by the arbitration clause. My lord will directly come to page 40, page 57 directly. Page 57. This is the paragraph 49 at page 57.
57.
57, para 49. This is their pleading as to cause of action in the instant suit. May I place this, Mullah? The cause of action of the present suit arose due to the defendant realize excessive interest and damages suffered by the plaintiff. This was also at the time of the plaintiff's repayment of the entire dues and the defendant's refusal to issue no due certificate till the month of so and so. Till that
admitted fact is, according to the plaintiff, loan has been repaid under the same loan agreement, right? After that, plaintiff claims some refund
excess
by claiming overpaid. That's the case, precise case in the plaint.
Absolutely. Absolutely.
Anything further to say?
Well, I'll just place for my own satisfaction at least this paragraph and one more paragraph, and then I'll conclude.
No, you can proceed in
That's
your
all.
own way.
It's a very small application. I did not show much
yes,
more.
yes. It is always a pleasure to hear all of you. Yes.
Well, may I just continue with this? This was also at the time, at paragraph 49, I'm continuing with. This was also at the time of the plaintiff's repayment of the entire dues and the defendant's refusal to issue no due certificate till the month of May 2022. Till that time, the plaintiff's account was operational with the defendant and the plaintiff was not made aware of any interest rate increase. That apart, the plaintiff at different points of time had suffered loss and damage because of the defendant's breach of contract. My lord will kindly note, breach of contract, specific government in the plaint. This is their allegation, which arose on different dates till such time as the plaintiff availed the loan till 20th May 2022. That is the date on which the no due certificate was issued. That apart, the plaintiff's cause of action against the defendant, Mullah will kindly turn the page, defendant is of a continuing nature for repeated levy and ultimate realization of excessive interest by the defendant. Page 58, Mullah, it's continuing.
Apart from cause of action against the defendant is of continuing in nature.
Yes.
For the
repeated levy and realization of excessive interest by the defendant. Squarely under the loan agreement, nothing outside of it. Mullah will now kindly see their pleading as to the arbitration.
Paragraph 51.
51 is also that's territorial jurisdiction. What has fallen from my.
They have admitted the execution of loan agreement.
Absolutely, Mullah. They rely upon it. Absolutely, Mullah. That's also there.
Then.
Para 52, I'll rest my case on facts on this. Para 52, page 59. The plaintiff's cause of action in the present suit arise out of defendant's breach of various Reserve Bank of India guidelines and directions. Apart from breach of the provisions of the contract, there is a purported arbitration clause in the contract, existence is admitted in the contract, which does not cover the cause of action forming the subject matter of the present suit. The said arbitration clause is also null and void. As per the arbitration clause, the defendant is to appoint an arbitrator who as a persona designate is the only person who as per the agreement would adjudicate the disputes arising out of the contract, being the arbitrator. Such provision is also null and void, being contrary to the provisions of the Arbitration and Conciliation Act as amended so and so. Their challenge in the suit, first and foremost, cause of action I've been able to establish, I hope, Mullah. Cause of action squarely covered under the arbitration clause in the loan agreement. Suit proceeds on A, a loan being granted by my client, B, payment being made under that loan, C, alleged excessive interest being charged upon the plaintiff by my client under the loan agreement. All three limbs of the causes of action as pleaded in the plaint squarely covered by the arbitration clause. And even after the Mullah has noted the use of the word thereafter at page Mullah in the arbitration clause, thereafter. So even the no due certificate does not extinguish the arbitration clause, it survives. Squarely covered under the arbitration clause. Their allegation only defends their Mullah will now kindly take up their affidavit in opposition. I'll just indicate their defense to the arbitration clause and how they're trying to deal with this. Mullah will kindly see page 4 of their affidavit in opposition.
Paragraph?
Well, that's a longish paragraph. Page 4, I'll just say. This is part of paragraph 3, subparagraph J. Paragraph I and J. Paragraph 3, I and J. Page 4. May I just quickly, please, my lord? ING. From a bare and meaningful reading of the plaint, and it would be evident that the plaintiff's cause of action in the present suit inter alia arises out of the defendant's breach of various Reserve Bank of India guidelines and directions. J. The issue as to whether there has been a breach of the guidelines of the Reserve Bank of India and the directions passed by the Reserve Bank of India on the part of the defendant is beyond the scope of the purported arbitration agreement. This is a case on affidavit. Well, will take it from me. After this, it's just repetition of the same. This is their case on affidavit in sum and substance. Breach
That's all.
of statutory. That's all on facts. To
read the arbitration clause and come out of your plaint case.
I would have possibly, but one thing I was wondering, whether this arbitration argument can at all be
Take the microphone.
whether this argument pertaining to the arbitration clause and referring the parties to arbitration, whether that can at all be entertained. This is not a Section 8 application. This is not an application for referring the parties to arbitration. My learned friend on the last occasion has relied upon the judgment of the Delhi High Court, which says that if it is brought to the notice of the court, it can be referred to arbitration without an application. But subsequently, this honorable court has considered that judgment and held that that is not the right law. I'll cite those decisions. That's the reason I would have possibly started off with the territorial jurisdiction point and possibly argued that this is a case where the forum selection clause will not apply.
I'm not on that.
Today, this is not an app. Kindly sees the prayers in the master summons. Where is the prayer for referring the parties to arbitration? Our High Court division bench included, I'll cite those decisions, has said
application is a must.
There's a must. So where is that application? And it has also been held that Section 5 of the Arbitration Act cannot be treated to be a bar of law under Order 7, Rule 11.
8 is the substantive provision.
8 is the substantive provision. 8 requires an application. Today, I would meet
the moment application comes, if the court is satisfied, yes, it is covered by arbitration clause. It's the mandate on the court to refer.
Mandate of the court to refer if an application comes. Today, because we are post affidavits, this point was taken when they moved the application that there is no prayer for referring the parties to arbitration. Still, post affidavits, this can't be improved now by way of a supplementary affidavit or in case that happens. I will, because since my learned friend has...
Yes, Mr. Counsel.
I'll meet that point head on, my lord. Page 6 of my application, my lord, will kindly take.
Sir, come to your prayer.
Prayers are there, my lord. My pleading is there. Admittedly, this is a fault. There is no specific prayer for reference.
Application.
May I just indicate one thing, my lord? At least 2 judgments we are relying upon of various high courts. Delhi is there, which says, I'll just...
Supreme Court is absolutely clear on this. Language of 8 is totally clear on this. Let us read the language of 8.
Right.
Party applies. Defendant on application. Applies. Hey, arbitration act do. Hey, to page. If a party to the arbitration or any person claiming through him or under him so applies. So applies.
My lord, my application, my lord, kindly consider my pleadings. Consider my pleadings, my lord. Once allow me to.
Pleading will not do, sir.
My lord, I've specifically said, kindly refer this matter to arbitration.
Very well, but your prayer is not that.
No, my prayer is not that.
2 ways to look at it. Either you take it back, I'm granting you leave to withdraw and file afresh. Or I'm dismissing it, I will grant you leave. Choice is yours.
Well, could I rely upon one decision which says even an Order 7 Rule 11 is sufficient? Could I rely upon...
Of Supreme Court?
No. You will then grant me time to take instructions, my lord. I'll take that instruction. My client's a bank, my lord. I have to take... It's an NBFC, I'll have to take...
Counsel, then I'm dismissing it, granting you liberty.
We'll kindly then consider this judgment only. Well, we'll keep it tomorrow. We'll take that instruction. We'll keep it tomorrow.
Passed over for the day.
Yes, master summons you to my lord.
Because of the expression and language used in 8, and you consider my judgment, I have also held if parties applies and court is satisfied, it is covered by arbitration, it's a mandate on court. But application must be there.
Fine.
Leniency is all right, but to a certain extent,
course,
so
of
long
course. This was a for I did
so
not-
long the law does not debar. Noted, noted. Noted. He will come tomorrow.
Take instruction and come back. I'll come back.
He will take instruction whether he will withdraw and file afresh or I will dismiss and grant him leave.
I did the judgments. Wasn't required. I told the proposition.
So yesterday I delivered one judgment where this is.
But that was the company law part. But the corporate bail lifting, I saw in live law.
Correct. But yes, but the paragraph is there.
Also,
paragraph is there.
I want to see the live law that judgment is reported but not published.
That I don't know. I tell you, it's there. Today morning also I have dealt with one service on corporation, how will it be affected, writ of summons. Because of this rigor of Order 8 Rule 1, new rigor. I've held that if parties applies and ultimately the court is satisfied, it is the mandate on the court.
The court won't apply on its own. That's the whole point.
Yes. Come tomorrow.
Item number 19.
Had it been his senior here, I would not have. It is always pleasure to be with the juniors. Go and take instruction.
Item number 19 is my application, my lord.
Yes.
My lord, my application for extension of time to file the written statement.
Beyond 30 days within 120?
Yes, my lord, was filed on the 76th day. My lord, the
File opposition.
objection.
Is filing opposition.
Yes, my lord, I've also filed my reply. I've served a copy on my lord.
All right, wait. Ashun.
So my reply is
This is an application filed by the defendant. Sole defendant, sole plaintiff.
Yes.
Defendant. You are there? All right. Asta Likhun. Mr. Shamrat Mukherjee, Learned Counsel.
Led by Mr. Shoroshish Dasgupta.
Learned Advocate, led by Mr. Shoroshish Dasgupta, Learned Advocate, appears for the plaintiff. Paragraph. MS?
Tiana Bhattacharya. Tiana Bhattacharya, I'll write it down.
Tiana Bhattacharya, Learned Advocate, led by Mr. Shomamo Ghosh, Learned Advocate Counsel, appears for the defendant. Paragraph. This is an application filed by the defendant praying for an extension of time to file written statement beyond 30 days, 30 days kotota bold, but beyond the mandated 30 days, but within the mandated 120 days under the amended provisions of Order Roman 8, Rule 1 of CPC. Yes, madam. Give me a list of dates. Show me. When writ of summons has been served.
Lord, this was a situation where, my lord, the suit was initially filed before the city civil court, my lord, where we filed an application for return of the plaint. Accordingly, my lord, the plaint was returned to be filed before the High Court at Calcutta. Because, my lord,
show me the date of service of writ of summons.
My lord,
when it has been converted into commercial suit.
The plaint, my lord, it was served upon us by an order of court on the date of its presentation, which is on the 19th of June, 2025.
Show me the order.
Yes, my lord. Lord, kindly takes page 18 of the application, which is GA2. Now at paragraph 9, issuance of writ of summons was dispensed with.
When the plaint was registered before this court?
My lord, on that day, 12th of June 2025. 12th of June 2025, my lord.
12th of June?
Yes, my lord.
No, the
Because it
order is of 19th December.
My lord is looking at the order dated 12th of...
Page 18.
Yes, my lord. It is of June...
Take the microphone properly.
My lord, the order is of 12th of June 2025.
We have a short innings today.
Come back.
Come tomorrow?
Yes.
At the cost of being severely reprimanded, Your Lordship.
Huh?
The cost of being severely reprimanded, Your Lordship. I apologize for keeping Your Lordship for 10 more seconds. Item number 23, Your Lordship, the learned
20?
23.
No.
The learned deputy sheriff is here. Your Lordship, the judgment letter number 4, he had surrendered before the learned deputy sheriff.
Achha.
Let's go.
লিখুন item number 23 তে।
The learned senior
That I appear for the
plaintiff decree holder.
decree holder. This is the third occasion.
Mr. Jayanto Sengupta, learned counsel with Mr. Orin Chakra.
Yeah, I'm opposing him.
I'm for the judgment letter number 4.
Oh, acha. Wait.
Lordship, I appear for the judgment letter number 6 and 7, Lordship, in this matter.
Wait.
My lord, may I mention, my item is 24. For last 2 weeks, I am coming and going back.
24?
24, item number 24.
কি হয়েছে?
Madam, this may kindly be fixed for any day.
I can release it, sir. No problem.
Release,
আসুন।
I don't want release, I
কি
want...
বললাম? Appears for
The decree holder, my lord.
the plaintiff decree holder.
Plaintiff decree.
Mr. Orin Chakraborty, learned counsel, appears for
Judgment letter number 4.
the judgment debtor number 4. Mr.
Ramiz Munsi.
Ramij
Munsi,
learned advocate, appears for
6 and 7.
judgment debtor number 6 and 7. Anybody else? The matter has been mentioned by Mr. Orin Chakraborty, learned counsel. On the plea that, pursuant to the direction of the coordinate bench dated
Your Lordship, 12th of November, you know. 12th of November,
November 12,
2025.
2025. Oh, so it is my order.
No, Your Lordship, this was the coordinate bench order for the arrest is of 15th of September 2025.
I'll just indicate your
warrant.
lordship, my lord. On 18th of August 20.
When he was directed to be arrested and produced.
Well, the first warrant of arrest was issued on 18th of August. The second one, my lord, was of 15th of September.
Acha. Submits that. Orin Chakraborty submits that. The first warrant of arrest was issued on
18th August 2025.
August 18, 2025. And the second warrant of arrest was issued on
15th September 2025. September 5th.
15, 2025, comma, as the judgment debtor number 6.
4.
Judgment debtor number 4 could not be traced out.
We were there, Your Lordship. We did not file our affidavit of assets.
Acha. Since the judgment dated number 4 chose not to file affidavit of assets pursuant to the direction of the coordinate bench. Paragraph. Today, now, where is your report, sir? Deputy Sheriff? कोई report टा देखी? Eta? Full stop. The report of the Office of the Deputy Sheriff dated April 25, 2025 shows that warranty could not be traced out at the address mentioned in the warrant of arrest then. Full stop. However, the warranty being judgment dated number 4 has surrendered today at the office of the Deputy Sheriff of this court. Where is he? Poster. Mr.
Ajay Chaudhary.
কি নাম?
Ajay Chaudhary.
Ajay Chaudhary.
Ajay Chaudhary. The warranty being judgment dated number 4 is produced before this court. Is produced to hobe na? Has appeared before this court after he surrendered himself. Paragraph. Mr. Ajay Chaudhary has been placed on dock, wherefrom he has undertaken that whenever he is required to be present in court, shall be present without any, shall be present henceforth. Full stop. Paragraph. Mr. Orin Chakraborty, Learned Counsel, appearing for the judgment dated number 4 stroke warranty, prays for leave to file the affidavit of asset. Full stop. Such leave is granted. Paragraph. The affidavit of asset found by defendant, judgment dated number 4, filed in court today, is taken on record. Full stop. Copy is served upon the learned advocate on record for the plaintiff decree holder. Paragraph. Since the warranty judgment dated number 4 has surrendered himself today in court, the matter has been taken out of turn upon mentioning. Full stop. The matter shall remain in the list, by retaining its position. In view of the above, the warrant of arrest shall remain suspended for the time being until further direction. Thank you. Thank you. बस ठीक है, থাকলেই হলো।